Please sit. Good morning.
How do we switch it off?
This is switch.
Council seeks permission to approach the dais.
Yes, please.
It is a live telecast.
105? Who will be the first speaker? Mohammed? 35. Second speaker?
Sir, this will be live in YouTube.
This is team 117. So, Your Honor, the petitioner side is team code 105. The respondent is 117. The speaker 1 will be speaking for 35 minutes. The speaker 2 for petitioner will be speaking for 25 minutes. The team code 117, which is respondent, speaker 1 will be speaking for 30 minutes. Speaker 2 for 30 minutes. We'll be starting.
It will be 1-1-1-1.
No, both the
both
petitioners
together?
and then the respondent.
105 and 117.
Yes, 105 is the petition. Starting with speaker 1 for petition. Council seeks permission to approach the dais. Thank you.
Am I audible? Council seeks permission to address the bench collectively as your lordships. Much obliged. Council seeks permission to submit the compendium of primary resources to the bench.
Good.
Thank you. Council seeks permission to establish jurisdiction. The petitioner has filed a writ petition and has approached this honorable court under Article 226 of the Constitution of Chiga. The petitioner has approached this Honorable High Court of Riga in apprehension of the violation of rights under the provision of the Anti-Cybercrime Amendment Act and bring forth the unconstitutionality of the provision because of the violation of fundamental rights. It is submitted that the petitioner is a pro bono lawyer and therefore has locus standi in approaching this honorable court. If your lordships permit, may I give a brief account of the facts of the case as well? Much obliged. Your lordships, the Republic of Chiga is a welfare democracy in the Southern Hemisphere with 100% 5G low-cost data coverage. The juveniles of the country are being brainwashed into assisting these cybercrimes, which are primarily started by foreign gangs who initiate these crimes. To prevent these increase in cybercrimes, the Anti-Cybercrimes Amendment Act of 2023 was passed and introduced on 31st Jan 2023. To further add to the provisions of this act, amendments were passed by way of an ordinance which was promulgated on 1st March 2023. This was following the report of the Riga tragedy on the 2nd of Feb, which was the suicide of 19 students of the nation. There were no results in the investigation for months, and only on 2nd December, there were 12 people who were arrested in relation to the case. The charge sheet was filed against 12 people, including 2 juveniles, on the 18th of December. The present petition, however, seeks to challenge the constitutionality of Section 354E, subsection 1 of the Anti-Cybercrimes Amendment Act 2023, along with the subsections brought about by the promulgation of the ordinance and its applicability to the present case. If your lordships give me permission, may I begin with the issues? Thank you, your lordships. Your lordships, in this regard, there are 3 issues which the petitioners will cover today before the court. I will be addressing you on the issue with regards to the constitutionality of Section 354E1 of the Anti-Cyber Crimes Amendment Act, which is whether it is arbitrary, vague, and ultra vires, along with the subsection of the ordinance which deals with validity of police confessions. I will do so for the first 35 minutes, post which my co-counsel will address the applicability and the constitutionality of the other two subsections of the ordinance for the next 25 minutes. If your lordship so please, I would like to begin with my first submission.
Yes, but once the investigation is over and the charge sheet has been filed, why are you going under 226 now and not asking for a quashing?
Your lordships, in this case, the petitioners are not, since there is this case is focused on the petitions for the constitutionality of the provisions. It is not a trial per se because there is no evidence on record right now. We don't know the facts of the case as well. Right now, we're only focused on the unconstitutionality of the provisions and whether they're applicable to the present case.
Charge sheet has been filed.
Yes, your
Charge
lordship.
sheet has been filed, so you know how the investigation has progressed.
Yes, your lordships. However, this post the preliminary hearing as the issues were formulated by the court, that is what we are concerned with at this moment.
You are affected by this ordinance.
How we are affected? Lordships, we are the counsel on behalf of the clients of Nlu Meg-Nhrc. The two juveniles in this case who have been arrested by the police are our clients, and they have been arrested under the...
Who has filed this petition? You being the advocate or your client has filed?
The advocate has filed the petition, your lordships. Your lordships, we are a pro bono lawyer. We seek that the lordships should strike down these laws as unconstitutional since they violate fundamental rights not only of our clients but of the citizenry at large. So, no, your lordships. However, since the fundamental rights are being violated of all citizens, as a lawyer of this nation, to ensure that justice is done, we seek that your lordship strike us down as unconstitutional.
Madam, in common law jurisprudence, the strict locus standi rule has been done away with, particularly after, if you're referring to Indian laws, after public interest litigation started. But that does not mean that you seek a remedy without any sequitur. If you're not affected by it, you can seek it on someone else's behalf, but here you've done neither.
Your lordships, with regard to the Anti-Cyber Crimes Amendment Act, it affects the entirety of the citizenry at large.
Maybe,
right.
But the order has to be implemented on something. Courts don't decide in vacuum, courts don't decide in theory. Once the court decides that this is wrong, it has to, therefore, what follows is this will go.
Yes, your lordship.
And the court does not decide, just that in theory this is wrong, therefore this cannot be implemented. There has to be a list, and in that list, it should be relevant. So on locus standi, it's really very weak.
Your lordship, since the ordinance also violates the fundamental rights of the citizens of the nation.
There's no merit in repetition, madam. You've had the same answer thrice.
Yes, your lordship.
There's no merit in repetition.
Right.
All right? But unless there's a sequitur to a relief which is sought, courts don't really engage themselves in this mindless exercise.
Okay. Understood, your lordships. However, I urge the court to consider the constitutionality of the provisions as well, since we are representing the clients who are the juveniles and who are concerned, and the applicability of the provisions as well. Even that concerns our clients, the juveniles, and so the ordinance must be considered
Then you have
as
to
a
make
whole.
out a terrible case where the court will go out of its way and say that this is so egregiously arbitrary that, the court will waive all propriety as to, locus standi. It has to be so violently unconstitutional.
Your lordships, the provisions are violently unconstitutional,
Carry
and
on.
we will submit that in our further submissions. Permission to move on with the first submission in respect to the Cyber Crimes Amendment Act. Thank you, your lordships. In this regard, we have two broad submissions. First, that Section 354E violates the fundamental right to freedom of speech and expression under Article 19(1)(a) of our Constitution. And secondly, the prescribed punishment in Section 354E Subsection 1, Clause B, violates Article 21 of the Chigan Constitution. This is the prescription of mandatory minimum imprisonment of 14 years. My lordships, moving on to the first prong, the freedom of speech and expression is enshrined in Article 19(1)(a) of the Constitution and is a cardinal value of a welfare democracy like Chiga. The Council submits that the section violates this right, since firstly, the wordings restrict...
Facts first.
Yes, your lordships.
You are challenging these ordinance.
Uh,
Promulgation 1st March 2023.
Your lordships, first, this council is challenging the Anti-Cybercrime Amendment Act of 2023, which is...
That says that newspaper reported some of the incident of suicide, which has supposed to be gone on from the 2nd Feb 2023, which is prior to the amendment.
Your lordships, that concerns itself with the ordinance, which my co-counsel will cover.
The ordinance doesn't cover this incident.
Your lordships, my co-counsel will touch upon the fact about how it does, about how the ordinance does not cover this incident. However, what I'm concerned with, what this council is referring to, is the Act and Section 354E 1A and B, which were before the ordinance, which concern itself with
Challenging subsection
A and B.
A and B.
Yes, your lordships. May I move forward? Thank you, your lordships. Moving forward, firstly, that it restricts the freedom of speech and expression. Secondly, that it is not saved by any reasonable restriction under Article 19(2), and further, it suffers from vagueness and overbreadth and should also be void on those counts. Starting with the first submission, Section 354E punishes persons or entities for sending or releasing articles, messages, and communications which are indecent and grossly offensive, or have the potential to be so. Council submits that these terms are wide and vague and thus lead to a large amount of innocent speech being curtailed. The absence of any definitions of these terms in Indian statutory law as well as this Act, or an ordinary understanding of these terms, means that each person has a subjective interpretation of what they mean. Further, they may restrict an individual from expressing their views and opinions, which may offend some individuals and not the others, and thus impacting their right to freedom of speech and expression. In Shreya Singhal versus Union of India, the court struck down Section 66A of the IT Act, Information Technology Act, for including precisely these terms, grossly offensive and indecent, on the similar grounds that they violate the freedom of speech and expression. And what council is contending is, on same grounds, this section should be struck down as well, and moreover, it widens the restriction post 66A, because firstly, 66A included in subsection which restricts false information. 66A also includes false information and added certain restrictions with false information which causes and such terms. However, this section only limits itself to false restrictions. Moreover, Section 66A mentioned digital communications, which this section does not, and also this section increases the purview beyond persons sending messages or communications to entities sending messages. Entities can be companies or even artificial intelligence, and such, which widens the restriction and the freedom of speech and expression. Your Lordship, the Constitution does put forth reasonable restrictions on the freedom of speech and expression under Article 19(2) of our Constitution. Council submits, however, that Section 354E does not fall under any of these restrictions. And further, it is not reasonable as well. Though under Article 19(2), reasonable restrictions can include security of state, etc. However, what we're concerned with at this point might be public order, morality, decency, and defamation, which can have some, as opposing counsel may contend, some connection to the current in the current purview of this particular section. However, starting with public order, the test for public order has been established as whether the punishable acts affect an individual or disturb current life of the community. Public order specifically focuses on the word public, as in the sensibilities of the society must be affected and not an individual. However, this section, yes, it may cover public order, as in the present case where public order was affected through the suicides. However, it also concerns individual communications and restricts those as well. So public order cannot be used as a defense for all communications covered under this Act. Moreover, Section 354E does not require a connection to morality and decency. Grossly offensive content need not be immoral. It need not be indecent to be punishable. And the same was established in Shreya Singhal versus Union of India as well, in which the court stressed in these factors when they came to that decision. Moreover, counsel would like to submit that in the case of Romesh Thapar, it was established, which if the bench would like to refer on page 96 of the compendium, that where a law purports to authorize the imposition of restrictions on a fundamental right in language wide enough to cover restrictions both within and without the limits of the constitutionally permissive legislative action affecting this right, it is not possible to uphold it even so far as it may be applied within the constitutional limits, as it is not severable. As long as the possibility that it can be applied for purposes not sanctioned by the Constitution, it cannot be ruled out that those purposes, the court will not apply to those purposes. It must be had to be wholly unconstitutional and void. And thus, in this section, having allowed imposition of restrictions on the freedom of expression, it has not limited the cases. And thus, counsel submits that it should be declared wholly void, unconstitutional on this ground as well. Moving forward to the grounds of vagueness and overbreadth, this was slightly covered in the submissions on freedom of speech as well. However, counsel would like to stress on this point that the provisions, when a person applying the law is in a boundless sea of uncertainty and freedom, and here the counsel is quoting A.K. Roy, and the law prima facie takes away this freedom, the law must be held to offend the Constitution. Your Lordships, every word in this provision, as we have stressed, may have several subjective meanings. How does an individual, the police, or even the court discern what is the difference between offensive and grossly offensive? If the individual does not know what they are being punished for, they cannot be convicted under the same. Moreover, even the word false information, which is under Roman numeral 3 of subsection A of the section, is broad, vague, and predicated on the existence of an objectively discernible truth, discerning which is not possible, and it might not be in the purview of the courts to do so. Again, reiterating similar grounds, Shreya Singhal versus Union of India, the court, on the grounds of vagueness, overbreadth, and the creation of a chilling effect, struck down the provisions as unconstitutional. My Lordships, the counsel, on these grounds, along with the fact that opposing counsel may contend that these words can be read down, or some restrictions may be read in by the court. However, counsel submits that reading down these provisions is not possible, for there is no understanding in statutory jurisprudence in India in the definition of these terms. And the court cannot create a definition on themselves on what these terms will mean. Moreover, the Attorney General in Shreya Singhal suggested that the reasonable restrictions be read in the provision, so to save its constitutionality. However, the court said that it would be against the intention of the legislature. If the legislature intended to do so, they would have included these reasonable restrictions in the section as well. However, they did not do so, and if the court does the same, that would be the substitution of the section itself, which the court must not do and must limit itself to the section in question. Your Lordships, this is my submission with regards to subclause A, subsection A of the Anti-Cybercrime Amendment Act. If your Lordships has no further questions, counsel would request permission to move to the second submission, which is subsection B.
Your argument is that one individual, whosoever is subject to this section, is not subject to trial.
Your Lordships, can you repeat the question?
Yeah. See, if anyone is charged under subsection A, is subject to trial, number one.
Yes, Your Lordship.
Any false information or a message which affect the right of the other person, right, that also he has all right to protect his own personal liberty and the privacy. So how you respond to that? Because there is a conflict between two individuals' fundamental right to privacy, right to dignity, as well as right to a fair trial.
Yes, Your Lordship. Your Lordship, what the council is contending is that, yes, this section can be used, and that is why the legislature brought it to protect the rights of certain individuals against for their rights to privacy, their rights to dignity as well. However, this section can easily be applied to cases where that is not so, and that is how it will restrict the freedom of speech and expression.
This is subject to trial.
Your Lordships, the...
Message or any information that whether it's a false or correct, that would be decided by the trial.
Yes, Your Lordship. However, the council is contending that even in a trial, there will be no certainty. There is the courts do have a certain leeway and discretion in deciding one way or the judges do, but in this case, there is absolutely no certainty. The individual itself, when the act is happening, does not know whether the act is offensive or not.
Your right to fair trial is not affected. You have all right.
Yes, Your Lordship.
And to protect your right before the court of law.
Your Lordship, we are contending that the offense, the question should not come to trial because.
The question is you are challenging. But how come a parliament can enact any act which can be called as an offense?
Your Lordship, the legislator does take in the will of the people and the best interest of the people while they're enacting legislature. Legislation, we agree to that. However, there have been many cases in which the legislature intentionally or unintentionally creates such a section which violates the fundamental right of the individual as well. Even in 66A, the legislature took into account the needs of the people, the increasing internet access and cybercrimes, and struck it down.
Everyone's right.
Yes, Your Lordship.
Group of the people in the society, there are separate groups of people. So the state has all responsibility to protect each one. So, and one hand, the offense, which of course there is a fact,
Yes, Your Lordship.
and there was a suicide, and suicide by the juvenile only.
Yes, Your Lordships.
So these are one group. The other group, of course, there are some certain kind of message which is circulated. Whosoever is. So there are right between the two parties.
Your Lordships, but in protecting the rights of one party, the fundamental rights of the other party should not be unjustifiably violated in this way. They are not taking any action, which, okay, thank you, Your Lordship. Your Lordships, my second submission is with respect to the mandatory minimum punishment of 14 years having been prescribed under subclause B of section 354 E1. Council submits that the right to not be subjected to cruel and unusual punishment has been read into Article 21, and Clause B violates the same as it fails the proportionality test. Coming to the first prong, the factum that excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted, which is the 8th Amendment of the US Constitution. However, it has been read in explicitly by Rajesh Kumar versus State of NCT in 2011, after Menka Gandhi came into play, into Article 21. That is, that no individual would be subject to cruel and unusual punishment through any legislative law. Even Vikram Singh versus Union of India, which noted that just because the courts are deferential to the legislature for matters of statutory punishment, that does not mean that punishments which may be shockingly disproportionate to the gravity of the offense be immune to constitutional intervention. Council submits the punishment in subclause B is shockingly disproportionate to the offense. My Lordships, the section imposes a mandatory minimum imprisonment of 14 years for each offense under the section. Offenses which may include sending grossly offensive texts as well. A mandatory imprisonment of 14 years. The contravention of Article 21 requires a disproportionate restriction of the same. The Council submits that this prescription violates 3 of the 4 conjunctive prongs of the proportionality test, since firstly, there is no rational nexus, it is not the least restrictive way of achieving the object, and the harms and benefits in this case are not balanced. Your Lordships, the objective of the provision is to combat the exponential increase in cybercrimes. Council submits that there is no correlation between higher punishments and deterrence, especially in respect to maybe juveniles and with respect to crimes over the internet and digital communications. These offenses may or may not affect society at large. Similar offenses such as sedition and obscenity laws are punishable with fines and a maximum 2 to 3 years of imprisonment, compared to a minimum mandatory 14 years in this case. The maximum punishment for any crime under the IT Act, which is the current act which is addressing such offenses over the internet at the moment, is 3 years, covering all sections of the act. The imprisonment in the impugned provision puts this offense at par with graver offenses such as human trafficking and murder. These acts are being considered more heinous than crimes such as rape, where the mandatory minimum imprisonment is 10 years. And here the mandatory minimum imprisonment has been raised to 14. The necessity requires that the legislation not have a less rights-restrictive alternative which causes a real and substantial effectuation of the proper purpose. The crime in question is dissemination and communication, not offenses of high magnitude, Your Lordships. Your Lordships, such acts, when committed on a smaller scale, unknowingly perhaps, to joke and make fun, and do not offend the community or sensibilities of societies, and yet they may even be punished under this section. An individual having sent an offensive text, mandatory being imprisonment for 14 years, is outrageous, inhumane, and serves no rational purpose, and affects their right to life and dignity under Article 21 of the Constitution. This punishment is not the least restrictive measure of achieving the same goal. Lower periods of imprisonment, along with imposition of fines, achieve the same purpose without affecting the rights of the individual, which we can see throughout our statutory legislation that exists at the moment in Chiga. A savage sentence, such as the amputation for theft, runs afoul to Article 21, which was noted in the case of Mithu by Justice Chandrachud. Your Lordships, with this, the Council submits that the mandatory minimum punishment is unjustifiable. It violates the Article 21. Moreover, the Council also further submits that this case does not require minimum punishment, minimum imprisonment, even being set, especially because the court should have certain discretion to take into account the intention of the offender, the harm caused, the consequences of the action, and then set punishment in that manner. However, this section ignores the same and thus must be struck down as unconstitutional, violative of the fundamental right of Article 21. Yes, Your Lordship.
After narrating the 4 kinds of action, it says, is guilty of an offense if their purpose is not bona fide or not one, as saved under any law. So the discretion of the court is still there to find that it is bona fide. Notwithstanding this having been done, to find that it is not a bona fide, that discretion is left to court.
Your Lordships, I understand the point you are making. However, even if the action taken is not bona fide under any other law, it may be,
This is either not bona fide or not protected under any other law. So there are 2 different kettles of fish, so to say.
Right, Your Lordship.
As you say, joke or something like that, a prank, court will take that to be bona fide. The discretion is still left there. You know, your argument is that the court has no choice in the matter. That may not be appropriate.
Yes, Your Lordship, I understand. Agreeing to that point, however, if the court may take that, this act, the offense that was considered, that took place, is not saved under any other law, and it may be a crime, may not be a crime of high magnitude, but still a crime all the same, then they have no other discretion than to impose.
So you want to say if the court finds some element of an offense, but there the court has no discretion but has to impose the minimum of 14 years.
Yes, Your Lordship, that is what that section we believe is contending to impose, and that is our belief.
The finding of court for the range or the magnitude of the offense will not have that, because the minimum is 14.
Yes, Your Lordship.
Offense is established, minimum is
14.
Yes, Your Lordships, and we believe that is
That's your
unconstitutional.
harsh disproportion.
It's shockingly disproportionate to the crime, Your Lordships. Your Lordships, with this, Council finishes their submissions with respect to the Anti-Cybercrimes Amendment Act A and B. Further, this Council will also discuss the subsection Clause D of the ordinance, which states, and Council would like to read out from the problem, that no person will be allowed to claim the benefit of being a juvenile for the purposes of this section and will be treated as an adult for all incidental and ancillary purposes. This is the subsection that Council will be dealing with the other 2 subsections and the applicability of the ordinance being dealt by my co-counsel. If Your Lordships permit, may I begin with my submissions with respect to the section? Thank you, Your Lordships. Your Lordships, starting with, firstly, that the section 354E1 clause D is ultra vires. Firstly, it violates international standards and protocols, which was an issue set forth by this court, that whether the subsection violates international standards, and it explicitly does so. Chiga is signatory to the International Covenant of Civil and Political Rights, the Convention on the Rights of Child, along with the Beijing Rules, which are the United Nations Standard Minimum Rules for Administration of Juvenile Justice, and the Universal Declaration of Human Rights, all of which protect the human rights along with the rights of juveniles. Coming to which, the CRC, Convention on the Rights of Child, states that state parties shall establish a minimum age below which children shall be presumed to not have infringed the penal law, or a minimum age of criminal responsibility. Moreover, Article 37A of the CRC states that a child cannot be subjected to life imprisonment. The provision in question, the amendment introduced by the way of ordinance, read with the Anti-Cybercrime Amendment Act to which it was added, in Clause B, which we just covered, states maximum imprisonment, maximum punishment as rigorous imprisonment for life, which is outrightly violative of CRC Article 37A, since it absolutely denies that a child can be subjected to life imprisonment. Moreover, the court may say that international obligations, yes, they do have persuasive value only. They may, in terms of municipal law, they may not have binding nature on a country like Chiga, even though we have ratified the same. However, courts in the case of Vishakha have noted that international conventions must be used not only to...
That's in the absence of any municipal law.
Yes, your lordships.
Not when there is municipal law covering that subject.
Yes, your lordships. Coming to that fact that they must be used, they must be read in line with fundamental rights and implemented in the implemented in municipal legislation. And council submits that they have been these principles have been implemented in the municipal legislation, which is the JJ Act, which council will just come to, and that act is also being violated by subsection by clause D of the subsection. The JJ Act mandates an inquiry to determine whether a juvenile of the age of 16 can be punished as an adult when they commit a heinous crime. Thus, it does create a classification between the two. This was added in recently in 2015, which means that the legislature is recognizing the need to decrease the defense of juvenility one by one. However, it is also setting safeguards in the understanding of preliminary inquiry that takes place to understand the maturity of a child before convicting them for an heinous crime. Such safeguards are not included in the current provision. Moreover, even the Chigan Penal Code provides for doli incapax till age of 7 and determination sufficient mental maturity till age 12. This is in section 82 and 83 of the Penal Code. Council submits that the clause D of the amendment introduced by the ordinance states that no person will be allowed to claim the benefit of being a juvenile for the purposes of this section and will be treated as an adult for all incidental and ancillary purposes. Thus, yes.
So there are conflict between special law and general law. JJ Act is of course a special law, and this ordinance is also a special law. So which will prevail?
Your lordships, the courts have noted that since the JJ Act includes a non-obstante clause, which is notwithstanding other provisions as well. However, the council submits, and the same has been noted by the state as well, that even clause D, which states the absolutes in no person, and the absolutes in will be treated as an adult for all incidental and ancillary purposes, creating a non-obstant clause over this one. And when the latter, and cases have noted that, that a latter non-obstant clause will prevail over a previous one when the two domestic legislations. Yes, your lordships. However, the intention of the legislature which is coming through, and the same, you will note that the respondents have also advanced this in page. The state is agreeing to the same in their memorial as well, that this, the usage of the word will and no person.
Too lopsided.
Yes, your lordships?
The problem is too lopsided. It gives only the challengers a right to propound a case. They almost have no case.
Yeah, your lordships.
To make it more difficult.
Yes, your lordships. However, the council contends that the absoluteness.
Tell us in law how to read, as my brother pointed out, how do you distinguish between two non-obstante clauses which have the propensity of negating each other?
Your lordships, just one moment, if the council may get the one, the compendium, and then. Your Lordships, what Council is submitting is that,
You're reading from phrase number?
Your Lordship, this is page 15 of the respondent's memo. This will be the respondent's memo on page 15. Your Lordships, the Council states that in Muhammad Irshad versus Shivraj versus State, wherein the court held that the latter non-obstain clause would prevail over the previous one, and in respect to the case in hand, there was no, Your Lordships, the latter non-obstain clause will prevail over the previous one, which is that the provisions of the JJ Act will be disregarded, and the provisions of this Act will prevail over the same one.
There is no non-obstante clause here to start with.
Yes, Your Lordships. However, the usage of the word will and the absoluteness of this is what Council is contending, that
So this-
it will take.
This is directly negating that without using a non-obstante clause.
Okay.
This is directly negating the JJN. There's no non-obstante clause over here.
So according
Yeah,
to you,
okay.
JJ Act should have an overriding effect over this provision. That is what you are trying to say.
Yes, Your Lordship. And if the JJ Act has, if the abstain clause in arguendo, if there is no if we accept that there is no non-abstain clause and the JJ Act has an overriding effect, then this ordinance has no value, because irrespective of what it says,
See, the cardinal principle is that the legislature would have been aware of the laws that have been previously passed by it. So if there's a previous law which gives protection to a particular group and a later law which negates that protection, it's the later law that prevails. The previous law does not prevail. So the argument that non-obstante clause will erode this is absolutely unacceptable.
Because there is a presumption of validity of a law.
yes, Your
That
Lordship.
presumption is something you have to combat when you are addressing on the unconstitutionality of this provision.
Yes.
You can say that this is wrong, this is in principally wrong.
Unfair.
Like, in Visakha, CEDAW was, the international conventions are violated, otherwise arbitrary, otherwise unconscionable, but you can't use the non-obstante clause.
Understood, Your Lordships. So the Council would then like to submit why the provision, since it's prevailing over the provisions of the JJ Act and as it's being taken by itself as overriding the effects of the JJ Act, then all the safeguards, etc., which have been included in the JJ Act will also not prevail, since this provision is overriding the same, which we have established. And now the Council will.
The JJ Act and this ordinance, both are to protect the rights and the safety of the children.
Yes, Your Lordship.
So this one, the juvenile, the juvenile cannot be as a defense. This exception is created to protect the children only, because the children are subject to suicide because of the so many faults.
In
and-
these facts of this case, we have to apply the law to the facts of this case. And here it was children, a mass suicide by children for the acts of your clients.
Yes, Your Lordships. We recognize that. However, sorry.
If this provision is to protect the children, then your argument that this ordinance is not meeting with the standards and the requirement of the international treaties is gone.
Your Lordships, it is to protect children in this case and to protect other individuals which may be affected the Act as well. Council Summit said we should not constrict ourselves just to this case. Moreover, just because the rights of the other children are being violated does not mean that we ignore the fundamental rights of the juveniles who are being convicted. The JJ Act guarantees rights to the juveniles, the children in conflict with law, and the ordinance takes away their rights, which is our next submission, which is regarding the unconscionability and the unconstitutionality of the provisions in this section.
Tell us, madam, does something happen around the midnight of 17 years and 364 days that a person assumes some kind of wisdom that yesterday he was good enough not to be excused and tomorrow he becomes unworthy of that excuse? Does something happen?
No, Your Lordships, that is not so. However, the Council would submit firstly that this standard has been created by the legislature taking into account certain factors such as mental maturity and how taking into account standards of society.
That is the point. Mental maturity of a person who can create a false message, if she can create a false image, a mock picture, his mental maturity is just like adult. So why not can't be prosecuted as an adult?
Your Lordships, the court has noted that the capability to commit a crime does not mean that the individual has the maturity to commit the crime. Just because they're capable, you can give a small child a knife and they might, by mistake or unintentionally, murder someone with it. However, does not mean they had the intention, does not mean they had the mental maturity to understand what they were doing.
Arguing the point of mens rea here.
Yes, and mens rea, the legislature must have has taken that into account in establishing the age. Moreover, council also submits that in Subramaniam Swamy it was noted that the age of 18 provides a good midpoint of focus, which may result in some amount of overclassification, yes, but that would be inevitable in any situation, and a midpoint reduces the chances of overclassification to the minimum. So the courts have recognized that this standard has been established by law and they've recognized the validity of this. And the council also submits that the heinous crime, 16 to 18, it is being reduced. So the amendments are taking into account the mental maturity of the children and how it's progressing step by step. And so this complete removal of any classification of all children, someone who's 2-3 months and 18 years, this is an unjustifiable provision that has been created. Yes, Your Lordships. However, the wordings of the section, just to point out the unjustifiable section that has been created.
That's the limitation of expression.
Yes, Your Lordships.
Expression by itself, whether it's written, whether it's stated, written is cold print. The emotion doesn't come out of it. When you say it, the way you articulate, the way you communicate, you indicate something. Sometimes a no is a yes, sometimes a yes is a no.
Yes, Your Lordships.
All right? Particularly, that's one of the excuses taken in rape cases in India. But when it's in cold print, there are certain limitations of words.
Yes, Your Lordships absolutely agree to that. And the legislature should not have added terms such as no person. And absoluteness of the term, that is, we contend that is a mistake on their part as well.
Kind of
Okay, Your Lordships. Moving forward to the next point about, I'm sorry. Yes, Your Lordships. Your Lordships, the CRC and subsequently the Beijing rules clearly state that the arrest, detention and imprisonment of a child shall be only used as a measure of last resort and for the shortest appropriate amount of time. This has been included in the JJ Act as well, that resorting to institutional care as a last resort, institutionalization as a last resort is a fundamental principle in cases relating to juveniles, which has been included from international covenants only. And the present JJ system has been enacted after years of deliberation and to secure the best interests of the child and with the primary object of social integration into society without resorting to conventional judicial proceedings that exist for adult criminals. This difference between adults and juveniles has been noted in jurisprudence in Chiga as well. Pratap Singh versus State of Jharkhand noted that juveniles must not be treated as par with adults, and the Supreme Court has recognized the fact that juveniles are required to be treated differently to give such children who for some reason may have gone astray due to their mental maturity and other reasons, an opportunity to realize their mistakes, to rehabilitate themselves and rebuild their lives. What the amendment and the act is doing is institutionalizing them for 14 years for the crime they have committed. No option of rehabilitation, no option of restoration into society because 14 years you've been spending in prison. And the court urges that is unjustifiable. The section violates the fundamental rights of juveniles as such, which was noted in Hari Ram versus the state of Rajasthan, that harsh sentencing is violative of the Article 21 of the Constitution for the juvenile. It's not proportionate to the crime, or it does not take into account the mental maturity of the child as well. Further, this juveniles are unequals who are being treated equally. And Article 14 states that this must not be done so. However, this inclusion and removal of any classification completely sets unequals at par. The gang members who have been in this particular case, who are the perpetrators of the crime, punishing them along with the juveniles who are maintained in databases who may be as young. We're not aware of the facts of the case, but who may be very young, punishing them at the same par is an over-inclusion, and they are not being treated as they must be considering all the principles which have been established and which the council touched upon. I urge the council urges, sorry. Your Lordships, may you repeat the question?
The principle of common object and common intention applies in this case.
Your Lordships, clause C will be covered, which refers to common intention by my co-counsel. So that they will refer to why it must not apply and why it's unconstitutional. And so I would like to let them answer it. Thank you, Your Lordships. Your Lordships, I urge the court to consider that punishing all juveniles for minimum 14 years will make rehabilitation into society impossible. And on these grounds, the council would like to submit that D is also unconstitutional, violative of the rights of juveniles, and that must also be struck down by the court. If Your Lordships,
Against restorative justice, is that what you're trying to say?
that is one of the prongs of our argument, yes. Which is a principle of Juvenile Justice Act, international obligations, jurisprudence of Chiga. So it's all violative of the same. Your Lordships, if you have no further questions, I would like to pass on the stage to my co-counsel for further.
Yes.
Thank you, Your Lordships.
Why do you address in third person? I've been talking about it. In courts, you don't address in third person. You don't refer to yourself as the counsel. First and foremost, that's a common Indian mistake. Counsel does not take any article, whether definite or indefinite. All right? So the counsel is completely wrong.
Okay, Your Lordships, that was a
Why
mistake.
wouldn't you address in first person? Why is it not I?
Your Lordship, counsel has made a mistake.
I've seen it in
And
No, not only you, it's in most
in
places.
most courts. Who trains you to do that? That's not how you address in court.
Your Lordships, I believe we will improve on that, and I'm sure my co-counsel will not make that mistake when he's
No,
addressing.
no, it's not a mistake.
Okay.
They're
It's
following that system.
Moot kind of philosophy
Practice,
is
yeah.
like that.
Council wants to argue on this, council wants
Whoever
to
has been
address.
training you has got it. After all, what is the moot supposed to be? It's supposed to be a mock court,
Yes, Your
all
Lordship.
right? And you're arguing as if you're in a court. In a court, if you ever walked into it, no one will say that this council says that, that council says this. It's always, addressing in first person.
Yes, Your Lordship. Lordships understood. We will take that into consideration. Thank you.
And secondly, you must be a lot slower in how you say it, because by and large, judges are of lower IQ.
Your Lordship, I think that's greatly underestimating judges
So
in
you
this
should,
case.
kind of
Okay.
not be so speedy. You should give them time to digest,
Understand what you're trying to say.
Because at the end of the day, madam, your job is to get the order. And if the judge does not digest it, he will disgorge something which is unpalatable.
Understood, Your Lordships. That also will be taken into consideration. Thank you so much.
It was a pleasure.
Your Lordship's apologies, I'm just arranging my documents.
But you must not betray signs of nervousness. Get a hold of yourself and then.
Your Lordships, my co-counsel has spoken extensively about the first issue, which is the constitutionality of Section 354E1 of the Anti-Cybercrime Amendment Act. I will be dealing with the remaining provisions of the ordinance after Clause D, as well as the applicability of the ordinance in the present case. With regards to the second issue, that is the applicability of the present ordinance in this case, I seek permission to begin my submissions with regards to the same. Thank you, Your Lordships. With regards to the same, I have three broad submissions to make before Your Lordships. First, that the said ordinance has lapsed. Second, that the ordinance was never applicable in the present case. And third, that the effects of the ordinance are no longer valid. I submit that the ordinance has lapsed.
What do you mean by applicability in the present case?
Uh,
There's no case. There's no case. At least your friend said that we are doing it pro bono only in theory. So what do you mean by applicability in this case?
Your Lordships, by applicability, we speak about the two juveniles who have been convicted under the said ordinance.
That was not challenged by them.
Their right of challenge is in a proceeding under a particular
And you
statute.
are not them, you are their lawyers, you are doing it pro bono in theory, that this is wrong. So if you say it's not applicable, then whatever you are saying becomes irrelevant.
Um, uh, I'm sorry, Your Lordship, I did not understand what you meant.
You say as this ordinance is not applicable to this case. Now, you're starting on a premise that this act or some parts of it, or the ordinance or some part of it, are unconstitutional. And there is no matter to which it is tied. If it were tied to a matter, then you could have said it's not applicable. But that's not your case. Your only prayer is declare them as unconstitutional. Let's go into an imaginary world where we can issue a declaration without a sequitur to the declaration. It's elementary. If you know the specific relief act, no declaration can be granted unless there is a consequential injunction. And that same principle is followed even in constitutional law, because constitutional law is only procedural. It's not substantive.
Yes, Your Lordships, I absolutely agree with that. But with regards to
So
this,
the moment you say not applicable, you're cutting your own argument. You're rendering your own argument irrelevant.
Your Lordships, by that, what I meant was that the ordinance was never applicable in the present case, and with regard.
What is the present case?
The present case that we are contending is with regards to the facts of the case that have been provided, which is the two juveniles being convicted
No.
under ordinance.
The present case is
Unconstitutional.
these are unconstitutional. Nothing beyond that.
Your Lordships, as per the issues framed under the preliminary hearing, which you can refer to in the facts, the court stated that these questions will be considered by the court. This is on page number 4 and 5, where the courts under 1C and D, where the court says that in this stage of hearing, they will also consider whether it is applicable and whether it is lapsed. Because further, counsel believes that it's important to discuss why it has lapsed, as discussed in AK Roy, that if it is proved that a certain ordinance has lapsed, and if it does not have, if a certain law has lapsed or it does not have effect
Of a law.
beyond the law, then
Disregarded.
then it should be disregarded, and even the constitutionality then is just a question of just theoretical understanding as such. Counsel seeks permission to begin their arguments with regards to the same. Thank you, Your Lordships. Submit that first the ordinance has lapsed.
Never say two things. Never say yeah in court. It's always yes.
Apologies, Your
Never say
Lordship.
thank you in court. It's you bow, you nod, you say I'm grateful. Thank you is something which is never used by counsel to judge.
Apologies, Your
Not in
Lordship.
our country.
Apologies, Your Lordship. I submit that the ordinance has lapsed as first the time period of the ordinance has expired. Article 85 of the Constitution, read with Article 123, clearly states that an ordinance can last for a maximum of 6 months and 6 weeks, which is 6 months as the maximum gap between any two sessions of either house of the parliament, and 6 weeks under Article 123 from the promulgation of the houses from the expiry of these sessions. This has also been accepted by the respondents in the first line of para 46 of the memorial, where they have stated that the ordinance has lapsed. Further, I would like to draw your attention to the facts on record, which clearly state that the ordinance was neither reintroduced or nor was any bill mirroring its contents ever tabled. Hence, the provisions of the ordinance in no form are currently valid or applicable. Further, with regards to the effects of the ordinance lasting, council would like to point out to page 24, para 46 of the respondent's memo, which talks about the same. Here, council, I would like to point out that the respondent's use of the words "is operable" in the heading and the rest of the body of the paragraph is in direct contravention.
Contrary argument. If it is lapsed,
Your Lordships, the respondents in their memo have said that even though the ordinance is lapsed, it is still operative, and I wish to rebut that argument of theirs from their memorial. So you can refer to their arguments on page 24, para 46 of the memorial, where they state that the ordinance is still operative even beyond the time frame. However, the case that they have cited itself says that an ordinance cannot be operable beyond the time limit. And further, even a plain reading of Article 123 clearly states that an ordinance shall cease to operate after 6 weeks from either house of the parliament sitting. That clearly states that the use of the respondents.
Say, theoretically, that there is a benefit which is conferred by an ordinance, or there is an obligation which is imposed by an ordinance. During that time, the benefit you're entitled to, or the obligation you're obliged to. Now, later, that ordinance lapses. What happens to the benefit that you're entitled to, or the obligation that you were obliged to discharge?
Thank you.
Just because it lapses means they are not there.
Absolutely, Your Lordship, that is exactly the case. And for that same, I would like to refer to page number 108 and 109 of our compendium, para 19 of Bhupendra Kumar Bose, which states that proceedings under a temporary statute will ipso facto terminate upon its expiry in the absence of a special provision to the contrary. However, an ordinance cannot even provide for a savings clause that will operate beyond the life of the ordinance in view of provisions 123 of the Constitution. This is further also substantiated in the case of Krishna Kumar Singh, which the respondents themselves have cited in their thing, where it is clearly where the other case that they have cited has been overruled specifically, which is I would just like to refer to that case as well. Which is the case of T. Venkata Reddy, which was explicitly overruled by Krishna Kumar Singh in their judgment, which I would like to provide to your lordships if you would like to refer to it. Your Lordships, for the same reason, I submit before you humbly that the ordinance has lapsed, it has ceased to operate, and no effect of the ordinance currently stands as valid, and no proceeding taken under the ordinance can continue for the same exact reason as that. So any proceeding that can be taken against the said juveniles or any person under the ordinance cannot be held to be valid under the court of law. Counsel seeks permission to address their next argument.
It could be a case that the state thought that it could be unconstitutional. So that was not the bill was not produced before the parliament, it was not passed.
Your Lordships, if it is not produced before the parliament, or if it is not passed, then the ordinance automatically lapses under. Yes, Your Lordship.
What is your stand now?
Our stand is that because the ordinance is lapsed, then neither clause C, D, and E stand valid in the court of law, so no person can be prosecuted under.
The ordinance itself is not in existence. There is no question of any unconstitutionality.
Absolutely, Your Lordship, that is exactly what we are contending, and hence that then ordinance has lapsed. But we still believe it is important to discuss the constitutionality regarding the same for the practical purposes.
Only academic.
No, for the practical purposes that this ordinance can be repromulgated in a very similar fashion.
What you are arguing essentially, isn't it what the defense case would be in the criminal trial?
Apologies, Your Lordship, I did not.
What you are trying to advocate here, that even if that ordinance has lapsed or the law was not applicable in the facts of this case or on the date of the incident, or when the charge sheet was filed and investigation, whatever the time period may be, isn't this an argument of the defense case in the trial, criminal trial?
No, Your Lordship, this cannot be made by them, as they have convicted said people under this ordinance, under the provisions of this ordinance, with regards to juvenile under clause D of the ordinance.
Convicted could have challenged before the appellate court.
Yes, Your Lordship, and that is exactly why I'm addressing this issue as framed by the court in the preliminary. Sorry, Your Lordship.
Convicted has challenged the conviction order.
Yes, Your Lordships, and this is what we are contending here, that there is no need to actually get into a trial as such from.
The investigation is charge sheet has been.
Yeah. So, under the said petition is the issues framed by the court in their preliminary inquiry. We are just addressing these questions so that this matter does not even need to proceed to a trial as such, as the ordinance has lapsed and no provisions can be of the ordinance can be applicable in the present case as it stands.
Are you aware of Section 6 of the General Clauses Act?
Yes, Your Lordship.
Now, that's repeal and savings.
Yes, Your Lordship.
Now, an ordinance lapsing is like the ordinance being repealed?
Absolutely not, Your Lordship. This distinction has been clearly made under Krishna Kumar Singh, where they at depth discuss the difference between an ordinance and a temporary statute or any statute that is repealed. So the General Clauses Act, Section 6 is not applicable in the case of an ordinance, as held in both Bhupendra Kumar.
What is the reason? As held it is irrelevant.
The reason is that the ordinance, the maximum, the limit of an ordinance's obligation or rights conferring is limited to the time period that is specified under Article 123 or Article 213 of the Constitution. Your Lordship, we could turn to page number 108 of the compendium I've cited.
Irrelevant.
Yeah.
First, you've got to understand before you vomit case law.
Yes,
What
Your
is the
Lordship.
principle?
The principle is that there is a difference between a temporary statute and an ordinance because, as laid down in.
You're repeating. What
Yes.
is the principle? You've not followed the principle, you're just vomiting out a case law.
Yes, Your Lordship, the principle is that the basic principle behind this distinction is that an ordinance is promulgated by the executive and it has been promulgated.
Basic principle is that upon the expiry of the period, the ordinance stands completely obliterated as if it never existed.
Yes, Your Lordship.
Whereas a statute, if it is repealed, is never obliterated. That statute existed.
Yes, Your Lordship.
That is the principle.
Yes, Your Lordship.
Follow the principle before throwing, judgments.
Yes, Your Lordship.
An
Apologies.
ordinance is usually promulgated to take care of an immediate urgent issue.
Yes, Your Lordship.
For when the parliament is not in session, it is not possible to make a law. So for that exigency.
Yes, Your Lordship. So exactly on that point, we are contending that.
Challenging the power of the governor to or president to issue such kind of ordinance.
Absolutely not. We are just pointing out that the lifetime of an ordinance for any rights or obligations created under it are limited to the 6 months and 6 weeks as the maximum capacity of any obligation the rights can confer. And hence, in the present case, it absolutely, and as recognized by the respondents themselves, it cannot apply in this present case due to this time period as specified under Article 123. Apologies. I seek permission to proceed with my next argument regarding the constitutionality of
The clauses.
the clauses in question. Your Lordships, my second submission is that regarding the constitutionality of clauses E and C of the provision, it is submitted that the provision which states that confessions to the police will be valid for all purposes under this section is ultra-vires because first, it violates the established principles regarding the validity of confessions to police officers, and secondly, it is falling foul of the right against self-incrimination. Council wishes to draw attention to paragraph 29 to 35 of the respondent's memorial. If your Lordships could just refer to it.
Why does it fall foul of doctrine against self-incrimination?
Your Lordship, simply for the reason because it is a ground reality in our country, as stated in NCT Delhi versus Navjot Sindhu, that it is an undeniable fact that the police in our country still resort to crude methods of investigation. Keeping this in mind, keeping the ground reality of our country in mind, there have been numerous case laws and statute, including Evidence Act from section 24 to 27.
27.
But
those are founded on section 27, where an exception is carved out. that no evidence, no confession before a police officer, but even there is an exception to that.
Yes, Your
For
Lordship.
instance, I make a confession to a police officer
Yes, Your Lordship.
in the presence of, let's say, 5 others.
Yes, Your Lordship.
Those 5 others corroborate each other that this confession was made. Then, independent of the police version, that can be taken into cognizance as long as it fits into the general structure. Now, this law says it negates the operation of 27. 27 is an exception to the general principle which follows over there.
Your Lordships, so if you could just refer to para 35 of the respondent's memo, the last line, they're speaking from the aspect that this clause is limited to just the provisions of section 27 of the evidence.
Fundamental. You're for the petitioner.
Yes, Your Lordship.
You're for the suitor.
Yes, Your Lordship.
You're wanting to establish something. You have to establish it, dehoards them. They can negate something you're trying to establish by referring to your pleadings. You cannot establish something you want to establish by referring to their pleadings.
Apologies, Your Lordship. So just to continue with regards to the same, if we could just do a plain reading of the section in question, it says all confessions shall be valid for all purposes. This is actually in contravention to section 27 and not on the same lines as it, as as all confessions and all purposes is not the intention of.
It's not all confessions, it's a confession.
Yes, Your Lordship.
A
So
confession. Secondly, as your friend has argued before, that like D, without having a non-obstante clause, overrides JJ Act. Similarly, E, without having a non-obstante clause, overrides section 27 of the Evidence Act, which the legislature is entitled to.
Yes, Your Lordships. However, before this court, I would like to submit that third-degree methods to obtain confessions is a reality in our country, and police always look to actually close the case quickly by obtaining this such confessions from the accused.
That
Here,
is taking us to surmises and conjecture.
Your Lordships, this is a ground reality in our country, and for that
How do
same.
we know? Ground realities come with evidence. How do we know?
Your Lordships, if you could refer to para 58 of Navjot Sandhu versus NCD Delhi, it states this exact para, that it is an undeniable fact that the police in our country still resort to crude methods of investigation, and this is a ground reality that cannot be ignored by courts.
Of division bench, 3 judges or 5 judges?
Your Lordship, this is a Supreme Court case of 2005. I'm not exactly sure of the bench strength of this case. However, this is.
There is a constitutional bench of 5 judges of Kartar Singh.
Yes, Your
Which
Lordship.
upheld the constitutional validity of section 15 of TADA.
Yes, Your Lordship.
So there is a similar provision contained there.
Your Lordship, the difference between Kartar Singh and this present case is that that when Kartar Singh and Tada were being considered in that present case, we can distinguish that as the security and of the nation was in consideration here. It was a wider ambit, and
Same here even.
Your Lordships, in this present case, even if the council accept that it might be for the security of the state, the larger purpose is to control cybercrime, and that could include the smallest of offences to the biggest of offences, and we need to keep that in consideration while deciding.
Scenario, the cyber security is the permanent important for national security.
Absolutely, Your Lordships. However, we need to recognize that even if cybersecurity of the country at large is one issue that can be dealt by this ordinance, the words used in it from subsection A and B, when read with this section, indicate that this section can be used for a variety of purposes, and for that same reason, it is not only limited to national security activities, which the TADA was specially concerned with. So this ordinance and this anti-cybercrime amendment can be distinguished as TADA was specially there to curb terrorist activities, while this is there to curb cybercrime, which is a different field altogether, and Kartar Singh hence is not applicable here. And along with that, there were several safeguards laid down in Kartar Singh, in the judgment of Kartar Singh, which have been ignored by this, as it has said that a confession will be valid for all purposes. However, the safeguards laid down in Kartar Singh have also been ignored. So that is the submission we would like to make before the court with regards to the same. Further,
If such safeguard can be granted by
Read it
this
to,
court,
read it to.
Yes, Your Lordship. So, if such safeguards can be granted by the court, we still need to recognize the difference between, as I stated before, between a terrorist activity related to national security and a cybercrime which could just be relating to annoyance or grossly
Are
offensive.
you aware that a few months back, all the defense systems were hacked into
Yes, Your
by
Lordship.
possible miscreants from a neighboring country?
Yes, Your Lordship.
So, how is that not? All logistics were disturbed. Central control had no access to the border areas where even some of our nuclear armaments may be located. How is that any less than Tada?
Your Lordship, to answer this question in two parts, that for an activity, a terrorist activity as such, we need to recognize that it's normally carried out by another state or actors of another state. However, keeping that aside, we also need to recognize, as my co-counsel here had stated,
Terrorist activities by another state.
they could be carried out by another state. So that is terrorist activities such as hacking into our defensive system could be or actors of another state as such. So that is one distinction. However, the primary distinction that I wish to make before the court here today is that merely because it can be used for a constitutional purpose doesn't ignore, and we can't supersede the fact that it can still be used for an unconstitutional purpose widely, as the terms used are grossly offensive, and as such that offense doesn't call for drawing a comparison between national security or a terrorist activity such as held in section 15 of the TADA or held in Kartar Singh, which also provided safeguard. So that is the distinction I'm trying to make, that merely because we can use this for a constitutional activity does not mean that
So just because there is no safeguard is granted in this act, does not mean the provision is unconstitutional.
yes, Your Lordships, but it is a ground. Yeah.
Primary or argument is just because there is no safeguard, that's why it's unconstitutional. That is not a valid ground.
No, Your Lordships,
And
we are.
any provision to be unconstitutional.
No, Your Lordships, apologies if it came out that way. However, we are trying to say that it is actually opening the leeway for the abuse of safeguards, as we need to accept that in our country, if there is a provision, as has been held in the case that I cited of Navjot Singh, if there is a provision, the police can use it to implement activities which are in contravention to the safeguards set by the court as well. So that is something that we need to consider. And further, in such a case, just to draw on to the examples of juveniles, under clause D, we need to recognize that when confessions of juveniles are taken, there are many safeguards present under the JJ Act as such. However, under this section, it is possible, when read along with section D, that is contravened. Even going further than that, we need to accept that juveniles are susceptible, due to their immaturity, to be actually influenced psychologically and by other physical means, possibly, to be able to give confessions that they perhaps do not want to give at that stage. So when we read this clause, we need to read it in entirety with the rest of the ordinance, which when we read it with the juvenile part, we can clearly find out that there is a massive scope of abuse in this particular section, which is in contravention to what the court should be looking at under Article 23 of the Constitution with regards to self-incrimination. Council seeks permission to move on to their last submission, which is with regards to the.
Do it one way. Either do it I or do it council.
Sorry. I further submit that the provision which states that criminal intention will be shared by any person abetting, or aiding or assisting any offense under this section is ultra-wise, because firstly, the phrase assistance of any kind is vague and might lead to arrest of innocence, and secondly, the assumption of criminal intention has no rational nexus with the objective of the act. So just to point out, the word assistance of any kind have been used. When we use this phrase of four words, assistance of any kind, it is important for us to recognize this is distinguished from aiding and abetting. When we look at assistance, it has been held that assistance, where aiding and abetting is sort of carrying out specifically directed assistance. So when we look at assistance of any kind, there is a possibility that the assistance might be without criminal intention as well. While the council concedes that aiding and abetting under the current jurisprudence possibly means that they do share the criminal intention as per our penal code, assistance of any kind should be specifically directed to further the object. And over here, the term is so vague that there is no certainty. And under Article 21, it has been held that procedure established by law should.
Can you give us any example of how assisting of any kind can be, kind of disproportionate?
Yes, Your Lordship. So, I would just like to give you two examples with regards to the same. So, aiding and abetting would be that a person instructs, or on a person's instruction, somebody carries out a particular act. However, assistance of any kind can merely just be that a parent gives a phone to, gifts a phone or something, because an assistance is a very wide scope. An assistance under misuse can also be used to say that the internet service provider assisted it by not actually curbing restrictions. So assistance of any kind actually does not carry intention with it in the very words of the statute. And hence when we read the clause in entirety, we can see that just by keeping aiding and abetting on the side, assistance of any kind just leaves the ambit of the application of the statute as so vague and so broad that there can be a scope of high misuse of this particular statute. Further, it is also important for us to consider that this statute uses the words deemed to have. This, if I could just.
Capable of.
Yes. So just to refer to the exact words of the statute, it says that will be deemed to be in conspiracy. So the word deemed here.
Oh, that part.
Yeah. So the statute in the ordinance part C says that aiding, abetting, assisting in any manner will be deemed to be in conspiracy and share the same criminal intention. However, when we use the word deemed, that places an irrebuttable presumption of guilt on the accused. Here, we want to distinguish that the word assumed has not been put. When the legislature uses or the executive uses for an ordinance the word assumed, that means that there is a rebuttable presumption which is acceptable in many cases and many acts such as the PMLA and the POCSO, which place a reverse burden of proof by using the word assumed. However, this statute used the word deems. Here, we tested by the constitutionality of reverse onus clauses set under the Sheikh Zahid Mukhtar judgment was the state of Maharashtra. We can clearly see that first of all, that the prosecution has to establish no basic facts with regards to the same, and secondly, and more importantly, it places such a high burden on the accused to rebut and be able to do away with this presumption, or with this irrebuttable presumption that they are faced with hardships and oppression. So in this particular case, when we read the section C in its subclause C in its entirety, we can see that any person assisting in any manner can share the same criminal intention. So it is possible that without having, and they will be deemed to have the same criminal intention. So without actually having the criminal intention, they are placed a reverse burden of proof, which is irrebuttable, is placed on them for assisting, for which they might not even know what the furtherance, what the actual end or the means was. And as we can see in many cases of conspiracy, such as Nalini or our penal code itself, when there is an agreement for conspiracy, they must there is an agreement. There must be like an agreement to further the illegal act. It has to be taken into account that for conspirators, either implicitly or explicitly, they should be aware of the object that they are being charged for in case of conspiracy. Here, as you can clearly see, when we read the words assistance of any kind with the words deemed, we can see that not only is such a hardship and burden being placed on them to rebut this presumption, but also there is a possibility that they might not be aware of the conspiracy in the first place themselves, and hence it falls foul of our existing jurisprudence and our statutory law itself. There is already precedent. Hence, the final submission of the Council stands completed. Councils would like to read out their prayers with regards to their submissions if your lordships have no further question. Thank you, lordship. Honorable Court may be pleased to adjudicate and declare that Section 354E1 of the Anti-Cybercrimes Amendment Act 2023 is unconstitutional. Second, the ordinance is inapplicable and has in the present case and has lapsed. And third, the provisions of the ordinance are unconstitutional. And pass any further order, relief, or condition which it deems fit and appropriate and suitable in the present case and circumstances. Thank you.
How come court can be passing such an order of the unconstitutionality of any provision which is not in existence?
Your lordships, this is just to point out that in case it ever promulgated again in the future or ever comes into the
How will
place.
we restrict the power of the parliament?
Court cannot do something. Court will not presume that the parliament is going to do something unconstitutional and give an advance ruling. That is not.
Your lordships, with regards to the same, there have been many presidents which have actually gone.
Not one. There could never have been even one. Not one. Don't please, these things never speak off the cuff.
Yes, your lordship.
No case for before court.
Yes, your lordship. Thank you. Apologies.
It's antithesis of the common law jurisprudence that we have. Yes.
The council seeks permission to approach the dais.
We've already said yes. Don't, mug up lines to repeat.
I would like to address bench collectively as your honors and individually as your honor. With the due permission of the bench, I would like to start with the issues. I would be dealing with issue number 2 and issue 1, sub issue B, and my co-counsel would be dealing with issue number 1, sub issue A, C, and D. With the due permission of the bench, I would like to further with my oral submissions. Before
Let us say that a person goes from place A to place B, and at place B, he sets up a prank which he circulates on the net. To get from place A to place B, he takes a metro. That metro has a driver. By definition, then the metro assists in the commission of the offense. By definition, in your provision, the driver also assists in the commission of the offense and can be found guilty under this provision. Is that rational? Because it says that it begins with entity. Person includes an entity. So Metro Railways as an entity is guilty of assisting because it carried him from place A to place B, and at place B the offense was committed, and the driver, carried the carriage. Driver is also assistance.
Much obliged. Your honors, while considering the assessing part, it must be understood with the intention of the person who has assisting.
Then what is the difference in aiding and abetting and providing assistance? Why are they different cups of?
Your honor, the relevant part of this section should be read in consonance with section 120A and 120B of IPC, wherein there are two basic fundamentals of criminal conspiracy. First is intention and agreement between the two parties, and it should be to do an unlawful act or to do a lawful act by unlawful means.
But there is no element of intention. The wording of the section is whoever aids and abets or otherwise provides assistance. Any person aiding and abetting any or all the above acts, or in any manner assessing the persons involved. There is no commonality. There is no section 34 principle over here of the Evidence Act or corresponding.
Pardon, Your Honor?
Also, there is a reverse presumption of deemed to be.
Your Honor, the thrust is that this section should be understood in consonance with the sections of IPC, Indian Penal Code.
Why?
to give it a desirable meaning by the Honorable Court.
Is there any provision in the Act which says that it must be read along with IPC?
Sorry, same.
There is explicitly not mentioned, Your Honor. It is
Then?
submission of
No,
counsel.
cannot be. IPC is substantive law. If there is any procedural law, say for instance CRPC, you could ask us to read it in consonance with CRPC. But when there is a special provision, a special set of acts which are made into crime by a particular statute, with penalties provided for the commission of such acts, then that has to be completely independent of the IPC. Companies Act, let's say, provides certain criminal offences with what would be the consequences. IPC does not come into play over there.
Apologies, Your Honor. The thrust is here is that the section should be understood with a procedural law which clearly distincts.
This is not a procedure.
IPC law is not.
Apologies for that, Your Honors.
Procedural is the criminal procedure code, not IPC.
Apologies for that. If the court may allow me to further with my submissions.
So the moral of
When
the
you
story
take
is,
apology, it means you accepting the argument.
the moral of the story is, if a chit comes, don't just look at the chit and say, think about it, whether it's right before you.
Your
Carry
Honor, the apologies was for misinterpreting the substantive and procedural part.
Carry on.
Your Honor, the second issue which is present before the court today involves whether the provisions of section 354E clause 1 are vague, arbitrary or ultra vires. Your Honor, the contention placed by me here is that the provisions of sections are not vague, arbitrary and thus are intra vires. The same would be substantiated by a fourfold argument. First, being there is always a presumption in favor of constitutionality of an enactment. Second, the court can construe and make a section workable by reading down to its provisions. Third, that the section is not unconstitutional on ground of being vague. And fourth, the punishment levied under the section is just, valid and reasonable. If there are no preliminary inquiries, the council would like to
Yes.
proceed. Your Honor, as it is a well settled position that there exists a presumption in favor of constitutionality, the same contention can be relied in the case of Nagaland senior government employees versus state of Nagaland, wherein, if Your Honors may please refer to note 1 of the compendium.
We are not questioning the proposition. Why do you bring us to a case? No one is questioning the proposition that constitutionality has to be presumed.
Your Honor, just to substantiate my submission.
Don't need substantiating when we don't question that proposition.
Your Honors, may I read what has been held by the court in that case? Much obliged, Your Honors. Your Honors, further, as it is evident from facts and the current scenario of the country, there has been 100% 5G penetration all throughout the nation. Due to this, there has been a widespread increase in cyber crimes. Hence, the juveniles, who are most vulnerable group here, they may be targeted, they may be brainwashed. So, in order to ensure their welfare and create deterrence among them not to commit such acts,
When you say brainwashed, that means they no longer have control over their minds. Persons who are juvenile have been brainwashed, they have no control over their minds. You punish them?
not for punishing them, Your Honor, just
That's exactly what your law is doing. They are brainwashed, according to your submission, which means that they have no control over their mind. And despite having done things without having control over their mind, you're punishing them.
Your Honor, the submission here is that for creating deterrence among them not to get brainwashed and not to get indulged in such kind of activities.
Do I have a choice when I'm being brainwashed? Do I go and tell anybody? Does a normal person say, come brainwash me?
Your Honor, the law is also there to create awareness among them. If
By having deterrence.
Deterrence.
To create awareness, you have deterrence.
apologies, Your Honor.
Are you apologizing for the act itself?
No, Your Honor, for the wrong submissions, Your
It's
Honor.
not the wrong
It's not
sub.
wrong
That is your
submission.
argument. You have
It's
to
your
just
argument.
ask.
You have
answer
a
to-
bad case. That doesn't mean you apologize all the time.
May I?
Try and change tack.
Don't be nervous, put your argument.
Try and don't.
You
Further,
have to answer. the point which the bench is posing to you is, do you punish a person capable of being brainwashed for an action or an act which a group was also misled into doing, and because of that some children have suffered? So you're brainwashing, both are capable of being brainwashed, both are under juveniles, both group, but why are you using that harsh measure on the group which, according to you, is capable of not being able to think on their own? Hence, why such a stringent law?
Your Honor, certainly
That is
the
the answer.
intention of legislature is not to create deterrence or not to punish any brainwashed juveniles or any brainwashed person. It is just to deter and create awareness and to punish the persons who are involved in these kind of activities voluntarily. If Your Honors may allow me to move further with my submissions. It was a dire need to create such a stringent law. If, for exemplifying purpose, the case of Riga school tragedy can also be taken into consideration here, where 19 students have attempted to commit suicide. This created a stress in society, and there was an immediate need was created to pass such a stringent ordinance and such a stringent act. Your Honor, it is pertinent to note that.
Situation existed only for that particular 6 months. Now it's solved.
Your Honor, I'm stating about this section 354E, clause 1.
No, but now the ordinance was not repromulgated or neither parliament has passed the.
And the date of incident is prior to the ordinance.
Yes, Your Honor.
The applicability,
That-
by bringing in the ordinance, how are you going to?
That issue would be dealt by my co-counsel in her submissions. If Your Honors may allow me. The legislature, Your Honors, is in the best need to understand the needs of people. Considering such a drastic and a dangerous situation in the country, the Amendment Act was passed. Your Honors, if you may allow me to move to the second limb of my
Why are you
argument.
repeating this? Have we stopped you from doing it?
No, Your Honor, I'm just seeking your permission.
No need.
Get rid of all this
It's
rubbish.
your right to submit your argument. You don't need permission from the court to submit your argument.
Apologies, Your Honor.
No, nothing to be there.
Your Honor, the second limb of the.
Move on confidently. Bad case, good case, answer your points, and address the court, whatever you are address, then move on.
Your Honor, this brings to the second limb of my argument, which is when the court, if the terms and some provisions of sections are appearing vague and cannot be given a definite meaning, the Honorable Court can construe and make the section workable and read down to its provisions. Your Honor, in case of Indian Social Action Forum versus Union of India, on note 3 of the compendium, if you may allow me to read.
You see, your arguments are all judgment oriented. You have to first make the point, and when you see that the ass sitting in front of you is not accepting your point, then you throw the judgment at him. You don't begin with a judgment. What is the point for which you're citing the judgment? You're citing the judgment that the court may read down. We accept the court may read down. What will the court read down? You've never come to that.
The council would be subsequently coming to that. The judgment has been cited just for substantiating the argument. Otherwise, it would have been the same words which has held in the judgment.
Here is, you can read down, you can harmoniously construe, or you have to construe in a way that provisions coexist. We have to, because legislature will not act.
You see, all of you must know that you prepare for a case. But that does not mean you prepare. It's not like a speech that A will follow, B will follow A and C will follow B. You have the case in support of your proposition. But if the court accepts your proposition, you don't need to cite the case.
First,
We
you
have a
have to be
question.
master of the facts. Hold on the facts first. Then, accordingly, you should apply the case law if
Yes.
required.
Yes, Your Honors. In the present case, the terms and the provisions of sections are being challenged by the petitioners on grounds of being vague. Your Honor, if the terms and provisions are appearing vague to the Honorable Court, the court can always read down to it and construe it.
Justify not vague because you have consciously used those expressions to carry a particular meaning. So don't presume court will think it's vague, so court should read down. First establish that they are not vague.
Then if you think that the court is not satisfied that they are not vague, then you go on to, you can read it down. You don't concede in the beginning.
If you may allow me to, if your honors may allow me to go to my third limb, wherein I am submitting that section is not violative of, the section is not unconstitutional on ground of being vague, and then the council will subsequently come to the question of reading down. If your honors may allow.
Continue. Don't seek permission, just continue with your point.
It is also a settled legal position that vagueness does not form a ground of, for a law to be declared as unconstitutional. Further, the language of section 354
Where do you get that law?
from the case of Municipal Committee Amritsar and another versus State of Punjab.
It says vagueness is not a ground for unconstitutionality.
If a section appears vague to the Honorable Court, if you may allow me to read from the judgment now. Yes, Your Honor, the Council would like to. In this case, the Honorable Supreme Court has laid down that an Indian Act cannot be declared invalid on the ground that it is vague, and if a law is vague or appears to be so, the court must try to construe it as far as may be, and language permitting the construction sought to be placed on it must be in accordance with the intention of legislature. Thus, if the law is open to diverse construction, that a construction which accords best with the intention of legislature and advances the purpose of legislation is to be preferred. Further, Your Honor, the language of section 354E, clause 1, is open to various interpretations. As we consider, it penalizes the cyber offenses. The cyberspace has been an ever-evolving space, and newer discoveries are made in it. There cannot be a predetermined way of committing a cybercrime. These methods can be invented with the advances in it. So, Your Honor, it is, if a definite and a constructive meaning is given, then a newer method which may be discovered of committing the cybercrime may not come under its purview. So, these new methods will again create a lot of dangerous situations in the society, and there will be no law for dealing with them. Hence, the language of this section has to be kept to interpretations of the court and give it the desirable meaning. If the court is satisfied with this submission, even though after considering this submission, if the court feels that the language cannot be given a definite meaning, or it is appearing vague to Honorable Court, then the concept of reading down can be applied here by the Honorable Court and give it a desirable meaning. Further, Your Honors, when a provision is appearing vague, when a provision is initially appearing vague, it does not have any meaning. It certainly has no meaning. Hence, reading down such section will not completely substitute it for a newer meaning, until and unless the interpretation given to it is in consonance with the intended intention of the legislature. The same has been contended by the petitioners that if a provision is read down, then it will if this provision is read down, then it will completely substitute it. The council states that if this section is appearing vague and initially has no meaning, then by reading down it, a meaning can be given to it. Hence, it will not substitute it completely, rather it will make it more clear and understandable. If your honors may allow me to move to the last limb of the argument, which is about the justification of punishment. Your honors, the matter in hand involves a commission of a heinous crime. the degree of harm it has caused to society is not measurable. And a legislature, while making a law and determining a punishment for it, keeps in mind some fundamentals, which are the potential harm caused and the deterrence it should create in society. Your Honors, the potential harm caused by these cyber activities are caused on the whole society. If we consider the group of juveniles, they are very vulnerable to it, and for such an harm inflicted on them, such a stringent law was the dire need of the hour. Further, it will create the deterrence in society as well as in minds of juveniles that not to indulge in such kind of activities which may lead which may lead to their harassment, or maybe they will be subjected to various penalties, stringent penalties. If the court is satisfied, the council would like to move on to submissions of issue 1, sub issue B.
We are not satisfied.
The council would most humbly assist the court with satisfying their submission.
Who has taught you all this rubbish? This is not how you deal in court.
Court will deliver the judgment.
We are not to tell you whether we are satisfied now.
Apologies, Your Honor. The council would.
Who is teaching all this? And I've seen it over the. You're not the first one. I've been seeing it over the years and criticizing it. Yet this goes on. Is there an international standard for this?
Is it how you address in those international moots?
On my personal level, I haven't done any international.
Because this seems to be a practice everywhere.
Everywhere. All moods have that.
So
There was another one I went to last. They also did it the same way. Third person.
Apologies, I won't repeat these kind of mistakes.
No.
You
but
find out.
you've heard.
You find out because we may not like it. Another set will tell you why you're doing
There
this.
must maybe
There must be a standard.
standard
You
which
must
you are
find out.
following, probably. That's why it's coming down that way.
Moving on with the sub-issue B, that is whether the provisions of ordinance are intra-vires. The council I humbly submit that the provisions are not ultra-vires and are just and valid. The first clause which is in question is clause C, which is about the deterring collaborative activities. As submitted by the council, it should be understood in consonance with and in aligning with section 120 and 120B.
Why wasn't it placed before the parliament if there was so much of good intention behind the promulgation of the ordinance? Why did you give it up?
There were large-scale public outcries and a situation of hocus was created in the country.
So then say it's irrelevant. The entire argument on the amendment is irrelevant since you abandoned it. You're the state, I suppose.
Yes.
Yes.
If it's your submission that there was a lot of hue and cry for which you did not re-promulgate it or make it a statute, it means it's gone. So the entire argument is irrelevant.
Certainly, Your Honor, but this issue has been set by the Honorable Court to be discussed in this hearing. That's why the council leads.
Yes.
Your Honor, this clause C is aligning with section 120A and 120B of IPC.
We have rejected that argument before.
Apologies, Your Honor. Moving on to submissions on clause E of this ordinance.
First you justify C.
Oh, much obliged, Your Honor.
You justify C without referring to the penal code.
Your Honors, while committing any offence under this section, if we take the example of present case of Riga school tragedy, the juveniles have been paid to handle the social media identities and circulate their images to the organized gangs. This establishes that there had been a clear intention of them to do an unlawful act. Furthermore, Your Honors, the intention of any person can be deducted directly out from the person's knowledge about the act he is committing. Herein, the juveniles had the knowledge that they are circulating the images and the social media identities to the organized gangs, and in return, the organized gangs used to pay them and morph the images and threaten the people whose identities were given to them. This establishes that that the juveniles were assisting the organized gangs in commission of such offences. In commission of such offences, and their intention has been established by them being paid from the organized gangs of doing such a heinous act.
What is your intention of including any manner whatsoever?
Your Honor, the assist.
Aiding and abetting was already there. Assisting in any manner whatsoever. Why? What was your intention behind using those terms? Because you will not act in surplusage. You have to have a reason behind using that expression extra. So what is your argument on that?
Your Honor, may please pardon and more elaborate on.
In C, you have said any person aiding, abetting any or all of the above acts or in any manner assisting. So what was the need for using that in any manner assisting? Aiding and abetting means assisting in the commission. So why extra? Why that extra expression?
Your Honor, as this amendment is about the commission of cyber offences. In cyber offences, the assisting may come in various forms, like circulating some kind of articles, messages, putting it on a big handles which have a greater reach than an individual. So it should be considered in that manner, and assisting should be considered in that manner.
Yes.
Your Honor, moving on to submissions of clause E, if there are no inquiries. The clause E states about the confession given before the police officers. It is humbly submitted that it should be understood with the section 27 of Indian Evidence Act. The word confession. The section 27 of Indian Evidence Act lays down that any statement made by an accused in police custody related to discovery of material fact, the part of the statement that distinctly relates to discovery, irrespective of whether it was made during a confession or not, will be admissible. Herein, the confession which leads to discovery of material fact given to the police officers shall be construed here.
But your subsection E says for all purpose.
Yes, Your Honor. Coming to that. All purposes under this section, Your Honor, the question section.
So how your section 27 will help you out?
If you may allow me to exemplify, if a juvenile, say during his confession given police officer, says that he have kept a laptop or pen drive in which he has kept the identities and the images of his peers, and such and
The basic principle is that the confession before the police officer as per section 27 is not admissible.
yes, Your Honor.
Whereas your subsection A, contrary to that, says the confession is valid.
Your Honor, the confession here should be understood in manner that if such confession leads to discovery of material fact.
Subsection E does not say accordingly.
Yes, Your Honor, that is not explicitly mentioned, but it is the submission of the council that it should be considered in such a manner. To defend the constitutionality of the provision, the council submits that it should be understood with section 27 of Indian Evidence Act.
Court does not have power.
Apologies, Your Honor. If you may allow me to continue with my example. If such a laptop or pen drive to which only that juvenile or the perpetrator has the access, then in that case, such a confession given before the police officer should be held valid. That leads to the discovery of a material fact. And it stands in consonance with section 27 of Indian Evidence Act. Your Honors, further moving to the last submission.
It completely negates the purport of E. Your concession. E is contrary to section 25 of the Evidence Act. Section 27 is an exception also to 25. If you want this to be read in consonance with 27 of the Evidence Act, it destroys the entire scope of the provision.
Your Honor, if it is appearing vague, then the scope should be limited and should be construed in this manner.
Yes, but again, in limiting it, we cannot legislate. We can interpret. What you're asking us to do is something that you can do yourself. Your
Yes.
concession goes to the extent of destroying the provision altogether.
Apologies, Your Honor. Your Honor, moving on to further submissions, going back to the issue 2, the punishment which is given considering the social context and social necessity in which the act was passed. Further, Your Honors, there had as there
Necessity lapsed. After 6 weeks, necessity went.
Your Honor, the section 354E still subsists. Your Honor, the ordinance has been lapsed. Section 354E clause 1 still subsists.
So the Parliament resumes session after 6 weeks from the ordinance, according to the problem. But you let it go.
The ordinance, Your Honor, as agreed by us with the petitioner, has been lapsed. But herein we are talking about this section 354E clause 1.
Yes.
Yes, Your Honor. Your Honor, if a reading to clause B of subsection 1 is given, that any article, message or communication which is intended to cause distress and anxiety or is of an indecent or grossly offensive nature and is used to blackmail, threaten, harass or extort anything in cash or kind is guilty of an offense if their purpose is not bona fide. Your Honors, here it should be construed that this sending of article under subsection B, which is intended to cause distress, should be followed by the cause of action should be accompanied with it being used for extortion, harassment, blackmailing, threaten. So these terms of blackmailing, extortion, threatening, harassment have been well defined and are not appearing vague. Your Honor, hence if an offence is made under clause B, clause B, which is intended to cause distress, then it should be accompanied with the actions of blackmailing, threatening and extorting. Furthermore, Your Honors, it is also left to the discretion of court to determine whether the purpose of the accused offender was bona fide or not and is saved under any law. So hence it is left to the discretion of court to decide whether the intention of them was bona fide or not. If the court is...
To you, the degree of offence of the intention to cause distress and blackmail and threaten is of the same level.
Your Honor, if you please may elaborate on this.
If you see B, my question is, the intention to cause anxiety and distress is equated with the offense of a grossly offensive act of blackmail, threaten, harassment, extortion. So for both, your punishment is 40 till life imprisonment. So the degree of offense for you, according to this, is the same.
The proportion of the punishment must be in line
Yes.
with the offence.
Yes, Your Honor. The punishment, the proportion of punishment here is in lining with the intention of legislature.
No, there must be the offence.
Yes, Your Honor. The offence committed under this is very heinous in nature, and this enactment was specially brought to deter such activities, of which the juveniles are the most vulnerable and the most targeted group. So, commission of offence against them.
We are on not a culprit, we are on the point of the offence. proportionality of the punishment.
Your Honor, the proportionality depends upon the potential harm it has been, the offence causes on the society. And
So you are equating an intention to do something to cause distress with same as a harassment, extortion, and blackmail.
no, certainly not, Your Honor.
Yes, both are punishable by 14 years to life imprisonment.
We are stating that a thing, an article communication which is intended to cause distress or anxiety, which is certainly being used for extortion and harassment, should be punishable for for the punishment levied under this section. Not both. Both should be understood.
Keep everyone in the same boat, the person who is storing the data and the person who is mocking the picture and sending to all.
Your Honor, both of them are committing the offence with the same intention.
But the gravity of offence committed by both of them is different.
Yes, Your Honor. For
It's only just storing the data, not circulating anything.
they are not.
One is circulating, even mocking the picture.
Your Honor, they are maintaining the databases of the social media identities throughout this period.
But I'm not committing any crime towards the society because I'm just storing at my place.
The accused person or the accused here is violating the right to privacy of the victims by storing and sending their
I'm not
images.
circulating.
They are not circulating. They are circulating it to organized gangs.
No, I'm not circulating at all. I'm just storing at my laptop.
Your Honor,
Stealing from you and storing in his laptop.
then it is just a breach of privacy, Your Honor.
I must be there with IT at them.
Yes, certainly, Your Honor.
In IT at the punishment, maximum punishment goes with 6 months.
Your Honor, here the punishment is set on the basis of the harm it has been inflicting on the society,
To whom?
to the juveniles and to both
I'm not
whole
I'm
society.
again repeating.
If Your Honor may please more elaborate, the council would be able to answer it more precisely.
My point is that a person who is just stealing a data from someone's account and storing in his own laptop. Okay, that's all.
Your Honor, that is not an offence under this section. This section is about where that person or entity sends or causes to be released those to public at large, those things like the articles, the messages, the images, when they send or cause it to be released. Then the offence is made out under this section. Just by storing, the offence is not made out under this particular section, Your Honors. Your Honors, continuing the submission on the clause B, a two-layer scrutiny has been put on, like when the action which is intended to cause distress has been backed by extorting or harassing. So this two-layer scrutiny is placed, and if first and satisfying the first, which is such information is sent, and the other being such information is used for harassing. So this interpretation has been submitted before the Honorable Court of the clause B. Much obliged, Your Honors. The council would now like to invite my co-counsel to further. Much obliged.
Your Honor, I will be dealing with sub-issue A, C and D of issue number 1. The A, C and D of issue number 1. To proceed with the submission of sub-issue A, there is which is about whether international obligation is valid, is operable or not. Your Honor, the ordinance is not in conflict with Chiga's international obligation because there is a prima facie presumption that a parliament does not intend to act in breach of international obligation as laid down in the case of PUCL versus Union of India. Further, Your Honor, it is also settled law that while construing any provision in domestic legislation which is ambiguous, that it is capable of meaning which is in conflict with or it conforms to the international obligation, the courts would presume that Parliament intended to legislate in conformity with the international obligation. Further, Your Honor, it is submitted and prayed before the Honorable Court that the Court shall proceed with the presumption that ordinance did not intend to breach the international law and is capable of being construed in such a manner that it remains in consonance with international obligation. Your Honor, here it is submitted that the impugned ordinance, the impugned ordinance was brought to curb the menace caused in the society due to the cyber crimes, specifically in the country like Chiga, which caused cyberbullying as a heinous offense. 19 students attempted to commit a suicide, which is the act of cyberbullying and harassment, is itself an immoral as well as violative of the human rights of the person. Also, Your Honor, it has been recently brought to the notice of the state that minors constitute.
We are asking the same questions to you, even. If the monarchy of the civil society is so prevalent, why this bill, this ordinance was not passed by the Parliament?
Your Honor, this ordinance has been lapsed and it was neither re-promulgated nor tabled before the Parliament. There might be a situation that Parliament was not in the session at that time.
Resume session after 6 weeks.
Yes, Your Honor. Your Honor, the Council will. Yes. Your Honor, can you please repeat the question?
Why this ordinance
Yes.
was not tabled before the Parliament?
Yes, Your Honor. Your Honor, this ordinance was not tabled before the Parliament as mentioned in para 9 because of the public outcry. Your Honor, it was not tabled because of that reason. But here, Your Honor, though because the ordinance is lapsed, the clients of the Nagchin's FIR should not be quashed because.
So we presume that the situation which you are arguing
Yes, Your.
regarding the outright
Yes, Your Honor.
this all cyber security and etc. is not true.
Your Honor, the situation that there was an outcry in this country because of the promulgation of the ordinance, a lot of international organizations as well as statutory child rights protection body of the country sent representation against the amendments. And because of this reason, the government neither reintroduced the ordinance, neither re-promulgated. But Your Honor, my submission is that the clients of Nagchin should not be their FIR and charge sheet should not be quashed only because the ordinance is lapsed.
They are doing it pro bono. They are the ones challenging the constitutionality.
Yeah.
They are not challenging it on behalf of the accused.
And questions of quashing the charge sheet or FIR is not before us.
Your Honor, the petitioners, as mentioned on paragraph 10, the two juveniles approached the statutory child protection body seeking legal assistance. Nagchin, a famed constitutional lawyer, agreed to lend her services pro bono in the matter, whereafter a criminal petition was filed under Article 226. Your Honor, in this present matter, the client,
Are you challenging the locus of petitioner?
Your Honor, the council is not challenging the locus of the petitioner, but Your Honor, the juveniles approached the famed Nagchin, a famed constitutional lawyer, lent her services to so that their FIR should be quashed. The FIR and charge sheet filed against them should be quashed. The Nagchin is.
No one argued before us that FIR should be quashed.
Your Honor, as it is mentioned on the council's opinion that. Your Honor, it's a prayer of the states that the FIR and the charge sheet should not be quashed.
So they have filed seeking quashing. You're right.
Yes, Your Honor.
But you have to advance arguments on their locus.
Yes, Your Honor. Your Honor, their
You say the clients should not be quashed. You have to answer it why it should not be quashed. So build up your argument. You're saying
Yes.
there should not be quashed. Build up your argument on that.
Your Honor, their FIR should not be quashed. It will be answered further in my submission. If it may please, I will answer afterwards. Your Honor,
Try to challenge the locus. Can you build up an argument?
Your Honor, the locus can be built that, can I take the Bare Act?
Do they have a locus to ask for quashing of the FIR and charge sheet?
Your Honor, the
That is what you have to address.
yes, yes, Your Honor, in the Your Honor, I am not finding the provision that it is around 4 Council 6 2 seconds. CRPC provision, it should be Article 226. The petition must be filed with the Article 226 read with Your Honor, under Section 482 of CRPC. The council, can I read this provision for submission? The provision says that saving of inherent powers of High Court, nothing in this court shall be deemed to limit or affect the inherent powers of the High Court to make such orders as may be necessary to give effect to any order under this code or to prevent abuse of the process of any court or otherwise, so just to secure the ends of this. Ends of justice. Your Honor, the criminal petition was filed under Article 226, which must be filed under Article 226 read with 482, which is about the inherent powers of the High Court, under which the quashing.
Inherent power of High Court under to quash is under 482.
Your Honor, it is
46 is the power to issue writs. Now, this advocate has filed an application before the under 226 asking for certain reliefs, which includes a prayer for quashing of the FIR and charge sheet issued against two accused persons, some of the accused persons, amongst whom two are juveniles, of an incident which took place before the ordinance came into the picture.
yes, Your Honor.
And the punishment is, they are trying to implement the punishment of offences which are being brought in by the ordinance.
Yes, Your Honor.
To justify the ordinance.
Your Honor,
They are saying, charge sheet is, investigation is over, FIR, investigation, charge, file. Now
Yes.
trial.
yes, Your Honor.
At this juncture, an advocate comes and says, quash those. They have not come. So what the bench is asking you to answer is, what is your answer on their locus to approach the court under 226 for prayers of this nature?
Yes, Your Honor. Your Honor, as there is no stand of the petitioners on quashing of the charge sheet, they are going against what had prayed for in the preliminary hearing. Your Honor, if it may be, please refer their memorial submission. In the prayer, they had never asked for the quashing of the charge sheet, which they had asked in the interim relief when the interim relief was granted by the trial court. So they are going against their own. So they are not having any locus to file a case under Article 226 of Constitution of India.
So they don't have a locus, according to you.
Your Honor, they have locus to file the case, but in their prayer they have nowhere mentioned about the quashing of the FIR and the charge sheet.
All right, next one.
Yes, Your Honor. Your Honor, continuing with the international obligations issue. Your Honor, it is submitted that international conventions and treaties like CRC itself provides a sufficient room for the countries to provide the law in such a manner which fit to the needs of the child. Your Honor, on page number 13, para 8 of the memorial submitted by the respondents, it is mentioned that under Article 3 of CRC, which reads as, in all actions concerning children, whether undertaken by public or private social welfare institutions, courts of law, administrative authorities, or legislative bodies, the best interest of the child shall be primary consideration. Your Honor, this implies that.
Therefore, any document submitted to the court,
Yes, Your
first ask the court whether you have found that relevant there or not, which you are trying to refer.
Your Honor, I referred that page 13, para 8.
The court has gone to that particular place.
Apologies, Your Honor. Apologies. I will not repeat the same. I will not repeat. This implies that, Your Honor, it is on page 18, para 8 of the memorial submitted by respondents. This implies that immunity of being a juvenile is not a fixed rule, but a flexible rule that can be adjusted according to their specific needs and situations of each child. Further, Your Honor, in para 9 of page 13 of the memorial submitted, Article 40 of CRC further reads about the same. Herein, Your Honor, it is submitted that, pertinent to note that, along with the individuals of child, equal importance has been given to the interest of the society, and a lot of space is left for the determination of these subjectives. Your Honor, to continue with this submission, herein it is argued that if a harmonious construction is drawn between Juvenile Justice Care and Protection Act and the impugned provision, proper effect to Chiga's international obligation could be given, as mentioned on page 14, para 10 of the memorial submitted. Your Honor, the objective of the JJ Act is to to protect the juveniles. Further, Your Honor, it is based on the treaties like and whereas the Government of India has acceded on the 11th December 1992 to the Conventions on the Rights of Child adopted by General Assembly of United Nations, which has prescribed a set of standards to be adhered to by all state parties in securing the best interest of child. Further, Your Honor, it is also stating that the standards prescribed in the Convention on Rights of Child and Beijing rules and all the international conventions are being followed. So, Your Honor, no, Your Honor, it is the objective of the Juvenile Justice Act. That is, it is also in the consonance with the international obligation, and by applying harmonious construction between JJ Act and the present provision, it is same that the present provision is also in consonance with the international obligation. Yes, Your Honor, I will assist. Further, Your Honor, it is pertinent to note that Section 15 of the Juvenile Justice Act, of which relevant extract in simple words reads as, in case there is a heinous offence committed by a child who is between the age of 16 to 18 years, he shall go through a preliminary assessment, and if he passes the preliminary assessment, he will be treated as an adult under Section 18 Clause 3. Your Honor, it is pertinent to note that at this juncture, a blanket immunity has been provided to the children who is below the age of 16 years. Your Honor, it means that even if the juvenile who is below the age of 16 years is alleged to have been committed a heinous offence, he will be protected by this section and he will continue to do so, and he will get a blanket protection. Your Honor, attention shall be brought to the next important provision, that is Section 18 Clause 3. Section 18 Clause 3 reads as, that the boards after preliminary assessment under Section 15 pass an order that there is a need for trial of the said child as an adult, then the board may transfer the case to the Children's Court, having jurisdiction to try such cases. Your Honor, two important points are pertinent to note here. Firstly, according to JJ Act, an heinous offence means any offence which is punishable minimum for 7 years. And secondly, Children's Court here is Sessions Court. Keeping this one side, the attention of Your Honor shall be brought to Clause D of the ordinance, which states that no person will be allowed to claim the benefit of being a juvenile for the purposes of this section and will be treated as an adult for all the incidental and ancillary purposes.
So the reference to juvenile protection is irrelevant here.
Your Honor, I am commenting on that. Your Honor, it is the council has divided this clause in two parts. First part reads as, no person will be allowed to claim the benefit of being a juvenile for the purposes of this section it is submitted that this part shall be read along with section 15 of JJ Act as a harmonious construction. Your Honor, clause D was indeed brought to override the blanket immunity provided to the children below the age of 16 years. Your Honor, a co-joint reading of section 15 with this particular part, that is, will be treated, no person will be allowed to claim the benefit of being a juvenile. Co-joint reading would mean that even if a person who is below the age of 16 years commits an heinous offense, he will have to go to the preliminary assessment.
To refer this JJ's Act in that ordinance then.
In the ordinance, Your Honor. Your Honor, it was...
If your argument is harmonious construction,
Yes.
in conjoint reading of JJ Act and the ordinance,
Yes, sir.
you should at first place bring out that JJ provision to that ordinance only.
Instead of saying nobody can claim protection as a juvenile.
Your Honor, it was to deter the juveniles from committing the cyber crime and to keep in the broader perspective, and by drawing the harmonious construction between the JJ Act, which was also a special act.
The state could have brought that provision,
Yes,
or
sir.
the JJ Act provision could have been applicable in the ordinance.
Your Honor, the JJ Act could have been applicable, but this being the special enactment, especially to deter juveniles from committing the cyber crime, whereas the JJ Act is different on that basis. So by drawing the harmonious construction, it is a stance of the state, Your Honor, to support that the ordinance was valid. So by drawing harmonious construction, it submits that the person will have to go, each and every juvenile have to go to the preliminary assessment, and if he passes the preliminary assessment under section 15, he will be treated as an adult.
The ordinance suggests anywhere that JJ Act will applicable.
Your Honor, the ordinance doesn't suggest there, but my submission is that by applying this manner, it will also deter the juveniles. It will also not in conflict.
We applied that. You, being a state, could have done it.
Your Honor, there was an urgent Your Honor, it is mentioned on page number 1 of the memorial of the proposition to strengthen the law as well as deter juveniles from getting involved in any such pernicious activities. Amendments by way of an ordinance, ordinance number 12 of 2023 was promulgated. That is, in any such pernicious activities specifically for the cyber crime, this ordinance was promulgated. Further, Your Honor, the second part of the clause G reads as, he will be treated as an adult for all the incidental and ancillary purposes. Your Honor, it is submitted that this shall be read in harmoniously with section 18 clause 3. Supposingly considering a situation where a child who is below the age of 16 has passed a preliminary assessment, and by conjointly reading section 18 clause 3 and this provision, this part of the provision, conjoint, apologies Your Honor, conjointly reading with both the provisions, it is inferred that the child who has passed the preliminary assessment under section 15, he will now be treated as an adult. Hence, Your Honors, it is submitted that if particular impugned provisions are read in this manner, they create deterrence among the juveniles, they also fulfill the objective of the law, and they are also not in conflict with the international obligation of CHIGA, since they are in compliance with the provisions of JJ Act. Further, Your Honor, moving on to the submissions of issue C if there are no preliminary inquiries. Your Honor, issue C is about whether the ordinance is inoperable as having lapsed. Your Honor, I am in agreement with the petitioner's submission that the council has lapsed as it is seen in under Article 123 of the Indian Constitution. But, Your Honor, it is pertinent to note here that it is all the charge sheet was filed primarily on the basis of the statements given by the approver before the competent court. Here the word primarily was be interpreted. Your Honor, the word primarily means that the charge sheet was filed majorly on the basis of the statements given. Your Honor, the council will further elaborate upon this also.
But this is not the question before us. Whether charge sheet will be valid, not valid, requires, not requires.
Your Honor, it is. The questions have been framed by the court. The questions have been framed by the Honorable Court for the discussion. Your Honor, the charge sheet has been filed majorly on the basis of the statements given by the approver and not solely on that. So, Your Honor, it leaves a scope for interpretation that juveniles were also involved in the sending act of not only maintaining the data of social media identities but also involved in the sending of the social media identities to the gang members who then morphed the images and threatened the victim. Your Honor, if the cause of action took, it is pertinent to note here that the cause of action took place before the ordinance was promulgated. Your Honor, it is the attention shall be brought to para 5 of the Moot proposition. Here it is mentioned that there was an organized gang. Can I proceed, Your Honor? There was an organized gang of criminals which had brainwashed some students and used to pay them for sharing their peers' social media identities. While reading along with the para 7, which says that the role attributed to them to have assisted in keeping a database of social media identities of students of Riga Public National School, Your Honor, after the conjoint reading of these two paras, it is submitted that the two juveniles were the same persons who were responsible for sharing the social media identities as well as for maintaining the data of the social media identities. Your Honor, attention shall be brought to the section of the Anti-Cybercrime Amendment Act, which was in place even before the ordinance was promulgated, and even after the ordinance has lapsed, it is in existence also. Your Honor, the relevant extract reads as, under section 354E, clause 1, clause B, a person or entity which sends or causes to be released to public at large or another sets of persons any article, message or communication which is intended to cause distress and anxiety or is of an indecent or grossly offensive nature and is used to blackmail, threaten, harass or extort anything in cash or kind is guilty of an offense if their purpose is not bona fide or not one as saved under any law, and the minimum punishment for such offense shall be 14 years and maximum for rigorous imprisonment. Your Honor, here it is submitted that the juveniles are liable to be prosecuted for the commission of such an act under this section, irrespective of the applicability of the ordinance as it has lapsed. Your Honor, firstly, the section says a person sends any of these things to another person. Your Honor, another person includes the gang members. The gang members who were then morphing the images, and it is submitted that students have shared their social media identities which constitutes an article which is used to threaten and blackmail the victims. Hence, Your Honor, it is submitted that irrespective of the operability of the ordinance, the juveniles are liable to be prosecuted under section 354E, clause 1, clause B of the Anti-Cybercrime Amendment Act. Further, Your Honor, if there are no preliminary inquiries, the Council seeks to proceed. Your Honor, the submission for section D, sub-issue D, which is about whether the ordinance, if it is held intra-vires, would apply to the facts of the present case. Your Honor, the ordinance is completely intra-vires. As the provisions of the ordinance are just and valid, Your Honor, clause C, which is about any person aiding and abetting any or all of the above acts in any manner, assisting the persons involved in the above acts.
You missed
Apologies, Your Honor. Or in any manner, assisting the persons involved in the above acts will be deemed to be in conflict.
Is this a disjunctive or?
Apologies.
Is this a disjunctive or?
Disjunctive or.
The word or.
Yes, Your Honor.
Do you know what is the meaning of disjunctive?
Apologies, Your Honor.
It's a very, very important tool in statutory interpretation. Whether it's conjunctive or whether it's disjunctive. You know, like you can say water or any other liquid. They are to be read eusdem generis, which means in the same sense.
Yes.
You say water or hydrochloric acid. They are disjunctive. in a particular sense. So over here, you say aiding or abetting the above acts.
Yes, Your Honor.
And then the next is or in any manner resisting.
Yes, Your Honor.
Does that mean that a person has to be aiding and abetting and assisting? Or a person can only aid and abet and there can be another set of persons who can only assist?
Your Honor, the second part, which the Honorable Bench mentioned, is the correct. That is, it is in the disjunctive application.
Now, aiding and abetting
Yes, Your Honor.
and assisting, this question we put to your colleague also,
Yes, Your Honor.
they convey different senses. How are these two conveying completely different senses accorded the same punishment?
Yes, Your Honor. Your Honor, it is submitted that abatement, as it is mentioned, Your Honor, but it is mentioned in the substantive law under 107 of IPC. It is not applicable here. But Your Honor, abatement, it is, Your Honor, any person aiding and abating. Abating means the who is instigating the person. So, Your Honor, if X person is instigating Y to, for example, release the morphed images, so both of them will be liable.
So what is the difference between aiding and abetting?
Aiding, Your Honor, aiding means assisting, and abating is instigating.
And therefore, there is aiding once as part of a disjunctive clause, which means assisting, and assisting again as another part of another disjunctive clause.
No, Your Honor.
That's complete anathema.
No, Your Honor. It is submitted that it is that the aiding. Your Honor, it is my fault that I claimed it as disjunctive, but it is conjunctive in nature because
Conjunctive in nature.
I will further
I
submit.
must aid and abet. I must also assist.
No, Your Honor. It is aiding and abating differently and assisting in any manner differently.
Disjunctive, then you are right.
Yes, Your Honor. It is disjunctive because, firstly, Your Honor, assisting.
The question is,
Yes, Your Honor.
aiding is an assistance of some form. So why did you need to add that extra in any manner assisting?
Yes, Your Honor. Your Honor, aiding and abating are conjunctive. That is, the person must aid as well as abate to be liable under this ordinance. Thereafter, in the second.
Can you aid without abetting? Or can you abet without aiding?
Your Honor, the person can aid as well as abate at the same time.
Let us take the case of suicide.
Yes, Your Honor.
I say jump, jump, jump. That is abetting.
Yes, Your Honor.
But I'm not aiding.
Yes, Your Honor.
And in another case, I take a rope. I said, this is the rope in which you hang yourself. I'm aiding and abetting.
Yes, Your Honor.
So how are they different?
Your Honor, the first instance in which you said jump, 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 in that you are abating the said person, but you are not aiding him as you didn't assisted, you also didn't committed the suicide.
These answers are not mother-wit answers. These answers are, you have to understand the principles.
Yes,
Aiding and abetting are used in the same sense.
yes, Your Honor.
The question started because you said aiding or abetting.
Yes,
It's never aiding or abetting.
aiding
It's
and
the entire act is seen as aiding and abetting. Whether I carry a rope
Or I say jump.
or I say jump, it's both situations are aiding and abetting. Alright? So
apologies.
you've got to understand the concept and not, and therefore, that's why aiding and abetting is a different
And assist.
act than assisting.
Yes, Your Honor.
But what is the distinction between aiding and abetting and assisting?
Yes.
Which is more culpable, which is more gross, which is more criminal?
Yes, Your Honor. Your Honor, aiding, I have to elaborate on this, that aiding, abating and assisting are different as the judge said. Your Honor, it is mentioned, it is submitted that aiding and abetting are done jointly, whereas assisting in any manner is different. For example, Your Honor, assisting in any manner can be said as, in the present matter, juveniles were keeping the data of social media identities. Your Honor, they are assisting the gang members in keeping the data of social media identities, where after that is, they are having the data of social media identities, they can anytime send them, and the gang members can morph the images and threaten the victim. Further, Your Honor, aiding and abetting are differently. So, Your Honor, if it is satisfied, the counsel seeks.
Yes, move.
Yeah. Further, Your Honor, clause D is satisfied, I suppose, because of the harmonious construction. By applying harmonious construction between section 15 and section 18, clause 3 of the JJ Act, the section D is also valid. Your Honor, section E, a confession given before police officer shall be valid also, as my co-counsel submitted. Your Honor, the counsel proceed with the prayer, if the bench is satisfied.
Proceed with the prayer.
You're not convicted, you have to stand up.
No, but our prayer, we are praying for this. Wherefore, in light of stated facts, issues raised, arguments advanced, authorities cited, submissions made hereto, above, and those to be urged at the time of hearing, the respondents most humbly and respectfully pray before this Honorable Court of Riga be pleased to adjudge and declare that the provisions of Section 354E are not arbitrary, vague, and intravious. The FIR and charge sheet filed against the clients of Nagchan
Are not arbitrary, vague and intravirus.
intravious, that is, it is within the constitutional limits. The Section 3 are not arbitrary, and they are intravious.
You did not say that. Are not arbitrary or vague or intravirus.
Your Honor, the counsel submitted that the provisions of Section 354E are not arbitrary, vague, and intravious. That is, it is within the Constitution. The FIR and the charge sheet, Your Honor, if you are not
Syntax is
satisfied.
wrong. Incorrect English, completely. Anyway, carry on. We understand the
Can
sense.
I elaborate?
Yeah, can
No,
I?
we have
We
understood.
understood the sense.
His lordship is saying that the way you have framed that
When you preface with a negative and you add commas, the negative attaches to all the expressions.
Apologies, Your Honor, but I am not submitting in that sense. I am submitting that.
understood what you
You understood what you want to say, but your expression is completely wrong.
Apologies, Your Honor.
Yes.
next.
The FIR and the charge sheet filed against the clients of Nagchan should not be quashed and pass. The FIR,
They are not asking us to question.
but Your Honor, the state.
Initial prayer was that, but the
Yes.
issues which have been framed, of course, there is
Very
an
good. We've
ancillary
understood
prayer.
that we should defeat them and we should
Allow the ordinance.
not
that what you want?
interfere with the
Ordinance.
act or the ordinance.
Yes, Your Honor. And pass any other relief in the ends of justice, equity, and good conscience. And for this act of kindness, the counsel on behalf of respondent is in duty bound forever to pray that this honorable court may be.
That they pray.
That they pray. And your petitioners, as in duty bound, shall ever pray.
Apologies, Your Honor.
You have to just demolish their case.
Rebuttal is not necessary.
Apologies, Your Honor, for all the trouble.
I think structurally, Vice Chancellor, you have to look at it how they are. If there's some international form,
Format, probably there is
then
a
there's,
format.
but otherwise this is gained currency all over, and I've been seeing it over my 15 years that I've been attending moot courts all over, from National Law School to Ram Manohar Lohia to everywhere. I've seen this, and this is not the way people address in court.
Apologies, sir.
Sir, in fact, this is the later edition which has added. It was actually not there when we.
Yes.
created
It's,
this.
it's not your fault.
It
That's
is
how you've
probably
been
an
trained.
international
No,
standard,
no, no, it's
otherwise
not.
why
No,
would
it
they?
cannot
It's
be
not
an
international standard. It's not an international
So they
standard.
are
International standard.
representing these
But
officers
the
who's
major
about-
problem is happening, it has copied from one to
Yeah,
one
one to
answers.
one, and
So
therefore.
that is going this.
Because if it is moot court, which is moot, in essence,
Yes, sir.
then it should be exactly like it is court. We are exactly acting as judges. You're addressing as lordship, which again you should not. Sir is good enough, but very good.
Thank you.
I'm
Next
grateful,
time
Your
in
Honor.
the regulation will include this part, sir.
No, but
No,
then
but
you
you have to
can't,
circulate all over.
Yeah.
Because these schemes come from other places.
Correct.
because, yes, because then a particular institution cannot enforce that kind of a standard. It's probably, it's been done all over.
At a national level, there are, big moots where you can, ask your representatives. You're too big for that. You ask your representatives to kind of circulate this idea that it should be how you address in court. Particularly people like you who participate in moots. You question why is it done and you say that, we pointed it out to you.
Because then it becomes like a debate speech.
Prayer is like just cut, copy, paste, but practically the prayer is the most important aspect.
Over. No. Let's finish it over here. We won't come back over here. Where? Valedictory is where? Yeah. आगे रिजल्ट तो होते एक्सीडेंट ना होते हैं पिछले कैमरों पे
You can take the stage. ভালো হয়েছে, very nice, very nice. It's a very pleasant, খোলামেলা তো, এই সব জায়গায়।
এটা তো নতুন বোঝাই যাচ্ছে খুব সুন্দর
And it's bright. Most of the auditoriums are so dark and gloomy. So give it to me. Good ছাড়াও representative respondent তো নম্বর দিয়ে দিয়েছি। Already? और just See, পারতাম না।
Yogesh, we don't need this anymore. No.
And Victor, come.
But that is the fun of it.
নেহু মানে আমাদের যে এখানকার যে ইউনিভার্সিটি
স্যারকে ওরা খুব রেগার্ড করে এই জন্য he has a lot of impact here for the district.
Yeah, he is very, I mean, he is an asset to the judiciary. Wasn't used properly.
এই দিক দিয়ে আমরা বাইরে
Sorry to interrupt you, but can you please write the field codes? If I got it right, the applicants from 105 and 116.
you take it out, you roll it and take it out from outside.
No, keep that room. That's little high. This is too low.
Come on, it's already time for felicitation. And get other students also will carry the things and give na. Three people, five people are being felicitated. Look at. I'll show you another time. Five people are being felicitated. ये और दी emotion ये first Sandeep Alessi, then Shankar Satya, then Jagdish Sir.
दो चेयर लगेगा वहाँ पे दो एक सिंगल वाला चेयर और लगेगा
How many are supposed to sit here? Two more.
5 plus 1 6.
Should we go in the corner? Excuse me. So it should not be too crowded because it will be very hot in here. Tano kam stige be young mo, tano kam kamon jopi. Kam stige tano
I request everybody to be seated. Good afternoon, esteemed guests, faculty members, participants, and students. It has been exceptional to have you all here as we mark the culmination of the first National Moot Court organized by NLU Meg in collaboration with NHRC. I extend a warm welcome to all of you to the valedictory ceremony. Without further ado, I would like to call upon Professor Indrajit Dubey, Honorable Vice Chancellor, National Law University, Meghalaya, to deliver the welcome address. Please, sir.
Good afternoon, everybody. Honorable Justice Sanjeev Banerjee, Founding Vice Chancellor of National Law University, Meghalaya, Honorable Justice Sampa Sarkar, Judge, Calcutta High Court, my good friend Professor Shukla, Vice Chancellor, National Law Northeastern Hill University, my student Jagdish Solanki, and all my dear student, participant, Badebu, my colleague in the faculty, staffs, registrar, every one of you. So I'm really happy today that we could, at the end of the day, complete the first national level moot court. And we are in existence for last 9 years. And I think, 9 months. And I think none of the law university, which I know, could organize the moot court competition of national level within this 9 months of time. Yesterday, I think I was talking with Pranay or some of my students there. So they told in IIT Kharagpur we have organized the first moot court after 5 years, national level moot court. And I think in Jodhpur also we have taken several years to start the national level moot court. So that way we were worried in number of font because there was a scarcity in the space. So one point of time Jogesh was telling me, sir, how you are going to manage, because there is no space to stay, where we are going to keep the student. And what he informed me that around 60 plus team was shown the interest initially. And one point of time I told him stop the registration because we don't have any space to go ahead with. Then he started telling, sir, well, now hotel has been managed, how we are going to manage the moot courts? We don't have so many courtroom. And his estimation was something around 25 room we require. Then we have requested to IIM also to give some room, and they are kind enough to give us 3 rooms to organize this function. So it has gone through a lot of difficulties. It's not so easy. But I'm happy to note that Team NLU, under the leadership of Jogesh, this time really delivered. And it was amazed to note that within this 42 team who has participated, there was a 14 national law school team was there from the different part of the country. So the team is not only from eastern part, but it actually from the southern part, western part, northern part, all across the country. And even in the private college and school, there the many top private college and school has been participated into this particular moot court itself. I also happy to tell about some of the achievement which I have made in this last 9 months. We have been nominated as a university out of 152 university in the country to implement the Viksit Bharat. So in the country at present, I believe 1700 plus university. We have a 1700 plus university, including IIT and IIMs possibly. Out of that, 152 university has been chosen to implement this Viksit Bharat. Our e-commerce artisan project is been selected to be showcased by the president, and this will be one of its kind in the country to these particular directions. In the academic front, we have completed the 2 trimester. Student has there into the internship for 4 weeks. They have got an experience and they felt quite amazed. And they have come back now. They are in a 3rd trimester. So soon, in 1.5 months, we are going to complete the next trimester also. And then they will go to the domain internship. So here we have crafted our program a little different than that of other law school. The domain we give a equal importance as it is of law, which is not so in other university or other law school in the country. So it is quite satisfying, that's what I was sharing with sir also, quite satisfying that within very short period of time we could achieve a number of milestone. This year we have notified to hold our exam for 13 cities in the country and 6 cities internationally. And I've been told there is a number of inquiries are coming from Sri Lanka, Nepal, Bhutan for the admission process. We have got quite a good number of applications in undergraduate and postgraduate as well as in PhD. And some of the senior officials also applied for the PhD program of us. So holistically, I believe this journey was not so easy, but we could make it. And I should extend the thanks to entire NLU team. And we keep on recalling sir and his contribution, the way we have put this particular university. Other day, a student was telling me, sir, we are missing sir, because he used to come talk with us and, deliver a lecture. So that warmth, that affection, we really miss. So I will look forward for your affiliation and connection to all of you, all the participants who have come. Please feel free to connect to us. Also, if you are interested to do participate some of the project which we are running here, please do apply for the internship here also, so that we can holistically connect with each other and we can develop ourselves. In the front of Moot Court, I was talking with Jogesh. Jogesh looks after that particular outreach program, that part of the outreach program. So maybe we'll also organize another Moot Court in this particular year, because Competition Commission shown the interest to hold the Moot Court here. And they are also interested to sign an MOU with us to build a capacity into this particular region. Next month, we are going to have another conference with UNDP. And this particular conference will be mostly financed by University of London. And they are interested to have a MOU with this university to implement many of the aspects of climate change. So I'm happy to note that we are taking a baby step, but we are doing things. And yesterday I was mentioning that when we have started with a few faculty without any support staff, whatever sir has given from the High Court and Judicial Academy. Then we have gone into recruiting the officers. Then we have gone to recruiting the other support staff. But yet, there is no multitasking staff in the university. And most of the thing is done by all the thing running around, entertaining everybody is done either by the faculty or by the staff. So we have started from the top. Now we are expanding. We have also gone for a faculty advertisement. Hopefully we are going to get another set of bright people We have got in a first process, there is a number of bright people, and we are hoping that we'll have another set of bright people. So thank you so much for joining this valedictory session. I welcome you once again to the NLU Meg, and please keep supporting to this baby university. We are taking a little step, and we hope that one day we'll create a difference and make an impact in the society. Thank you so much.
Thank you, sir. Now I would request Professor Indrajit Dubey to facilitate Honorable Mr. Justice Sanjeev Banerjee, former Chief Justice, High Court of Meghalaya, and I welcome sir to the dais. Thank you, sir. Now I would request Professor Indrajit Dubey to felicitate Honorable Madam Justice Shampa Sarkar, Judge, Calcutta High Court, and welcome her to the dais. Thank you, sir. Now I would request Professor Indrajit Dubey to felicitate Shri Jagdish Solanki, Supreme Court Advocate and Consultant, Ministry of Law and Justice, and welcome him to the dais. Thank you, sir. Now I would request Professor Indrajit Dubey to felicitate Professor Prabha Shankar Shukla, Honorable Vice Chancellor, Nehu, Shillong, and I welcome him to the dais. Thank you, sir. Now, I would like to invite Shri Jagdish Solanki, Supreme Court Advocate and Consultant, Ministry of Law and Justice, to address the audience.
Good afternoon, everyone. Honorable Justice Sanjeev Banerjee, Honorable Justice Madam Sampa Sarkar, Honorable my guru, my mentor, Vice Chancellor Nlu Meg-Nhrc, Dubey sir, Honorable Vice Chancellor, friends, students. This is really a great honor and privilege for me to be here And it's just like remembering my old days, attending the moot courts and facing the same questions, same kind of experience again. And for that, I thank everyone. Yogesh ji, thank you for inviting me and giving me an opportunity to live my life again as a student and experience the same thing. Being an advocate, my journey, I think Professor Dubey sir knows that. See, coming from humble background, things was difficult. But, if you take the challenge and do your hard work properly, you strategize your life in a proper way, things would be more easier than looks like. So, though I coming from a village, I done my graduation, 10+2, not graduation, sorry, from Hindi background. Then I entered into NLU. That altogether different atmosphere, different culture, everything was different. And at one point of time, I thought to quit and go back to a normal university to my BA LLB. And at that time, I think ma'am and sir, they met me and they said, no, I'll teach you. I'll teach you how to compete with this environment, culture, and the challenge which thrown my life to me. And I think you remember, sir, I think there was some extra classes for me, only for me. And that's how the journey started. And then I become an advocate for 2-3 years, joined a law firm. Then I become in-house counsel, become vice president in Bajaj. Then again I quit because there was some comfort zone. So the lesson what the reason for telling this story is that don't ever put yourself in comfort zone. The moment you feel that there is a comfort zone, leave it, quit it. Because the moment you feel there is a comfort zone, your learning would be stopped. Being an advocate, if your learning is stopped, everything would be stopped. You will die. Okay? Every day if you are learning, then being an advocate, you are alive. So read every day. Before going to bed, try to make a habit to read something. I'll tell you one more story of mine. I was traveling from Harda, that is in Bhopal, in MP. Harda to Gwalior in a train. And my habit is I don't get sleep, I don't fall asleep without reading something. At that day, I forget to carry any reading material or book. So I was searching something to read so that I can fall asleep. And fortunately, that at that time, the train stopped at a station. I came down and then I was searching something and I found a newspaper, piece of newspaper. And I was reading that. And there was some article and I was reading of that article, and that article containing a very particular message, okay, to how to judge a judge. Okay, so that one line I learned from that newspaper article, which I pick up from a station, that is the best advocacy is to judge a judge. Okay, so if you know how to judge a judge, you are the best advocate. So that one principal line taught me while traveling. And then I left the Bajaj because there was a comfort zone and I started my practice. Many people told me that you are insane. You don't know, because no one will leave that kind of luxurious job, corporate job. But I said, no, there was comfort zone, I will leave. I left that job, I established my own law firm. Now 42 advocates are working with me. And also because of my passion towards learning and my passion towards law, the Minister of Law made me his advisor even. So I'm involving many important aspects of Ministry of Law, including how to enact the law, whether the certain provision of bill can be held constitutionally valid or not valid. So the thing is that read every day, learn every day, and live your life king size. Thank you everyone inviting me. Thank you.
Thank you, sir. Now I would request Professor Prabhashankar Shukla, Honorable Vice Chancellor, NEHU, to address the audience. Sir, please.
Ex-Justice of Meghalaya, Chief Justice of Meghalaya, Honorable Justice Sanjeev Banerjee ji, Honorable Madam Justice S. Sarkar, the Vice Chancellor of NLU, and also the Advisor of Government of India in Law and Justice Department, Sri Jagdish Solanki ji, the advocate of the Meghalaya, and I'm looking the faces of young generation, having a kind of intellect to serve their duties as an advocate in future, to solve the problems of the citizen of the country. I think all of you have a good experience about law and what is the meaning of law and why we are studying the law. By nature, man is a social animal. We all have our society, but sometimes the animal word is also attached with this. Our habits, our activities, thinkings and others going to even affect other citizen of the country. That's why the beginners are our, after independence, the people of the country made a kind of system to discuss, deliver, and declare what is right and what is wrong. All of you experienced about the value of the Moot Court in the life of new law students, and I can say that the Moot Courts giving a new chance to our student how to write, how to interact, and how to present the cases, and hope all of you even made a good experience in law, in Moot Courts. One thing I would like to mention here, maximum young generations are here, and we are well aware our country is facing a number of problems, definitely the no court problems, and number of cases are pending in our courts. Our Vice Chancellor clearly mentioned that this is the 9-month baby. If we are going to inculcate a good seed in the mind of young baby, definitely the future of baby will be better. And two important words. One in I think you know the meaning of the Indrajit. And another thing from the side of the student, the Yogesh. Both are very important word in our country. That's why the Vice Chancellor and the student are able to conduct this kind of program within a 9-month period. Because everybody have 24 hours in the day. I'm always going to discuss this thing. No one have more than 24 hours in a day. It's only depend on you, your intellect, how to, and when, which way you are going to utilize this 24 hours for growth and development of your own life as well as your own society, region, country. So all of you have the intellect. All of you have the also chance of 24 year of the Amrit Kal. Because our Prime Minister thinking about the Viksit Bharat up to 2047. So all the young generation liars are having the time, having the chance to apply their intellect, to apply their brain for solving the problems of our state, region, as well as country. So I hope your experience and critical thinking, innovative ideas will be able to solve the problem of the consumers. With this, once again, thanks to the Justice, ex-Justice, respected Banerjee ji, and the Vice Chancellor of the University for giving me this opportunity. Thank you. Khublai Subun Mitela. Thank you.
Thank you, sir. Now I would like to invite Honorable Madam Justice Shampa Sarkar, Judge, Calcutta High Court, to address the audience. Ma'am, please.
Good afternoon. Honorable Justice Banerjee, former Chief Justice Meghalaya, Honorable Vice Chancellor Nlu Meg, Honorable Vice Chancellor Nehu, Mr. Solanki, Learned Advocate, Mr. Agarwal, Learned Advocate, faculties of Nlu Meg, the students of Nlu Meg, the organizers of the Moot Court, Mr. Yogesh Mishra, and all the Mooters. Congratulations to you. What a lovely performance. Please don't go by our interjections. That is only to test you on your feet, and it is a part of your mooting and learning process to make you ready to be counsel. Sir, thank you so much. Justice Banerjee, thank you for thinking of me as one of the judges of this bench. Professor Dubey, Learned Vice Chancellor, thank you for inviting me over. This break was a welcome break, mentally, physically. It was an enormous rejuvenating effect the beauty of the place had on me, and today the company of youngsters and young budding lawyers who have a lot of dreams. You're coming with a lot of dreams, and it is a wonderful journey. It's easy to be an advocate. You get enrolled and you become an advocate. To be a lawyer, it takes a lifetime. The entire journey and this entire process of being a lawyer, trying to be a good lawyer, is a huge process and a very, very interesting and exciting journey. I'm very impressed with the work that this has done. Sir, it's your baby. Professor Dubey, you're still nurturing the baby. And look at the
look at the wonders of this place. As I walked in, and this is a temporary arrangement. It is not the permanent concept of what Nlu Meg is going to look like in the next 4 or 5 years. But you walk into this place and you feel, yes, this is like an ashram where you can, really put your heads together and do a lot of meaningful work. The nature adds to that. And when you walked in, I was taken to a few classrooms which were high-tech. So it is great because when we were students, if we had this kind of ability, the tools that you get, we were far, far behind because of the kind of education, the legal education that we had was orthodox, conservative, and nobody was serious about the education part. It was only about passing the exam, get your license with the Bar Council and start running in court. That is how we started. But here, if you utilize all the facilities that are being given to you, that they are conceptualizing so many things, how to help the generations ahead, you are already more than half ready than we were to face litigation or any kind of job, because everything is now AI based, and your educational system, as it has been projected to us, seems to be highly dependent on technology, and there is a lot of skill sets which you learn from that. So that is a great advantage. You have a lovely high court over here. You have great chief justices coming. We missed Sir. He left Calcutta almost orphaned, but you have gained. So it was a big, big gain for having Justice Sanjeev Banerjee as the Chief Justice of Meghalaya High Court. So, and for the local people, when you have a functional High Court and you have an institute like this, nothing else is required. What a fine balance. We are expecting great lawyers will be, you will be producing great future lawyers in the future, and they will do very well. All the best to all of you, and again, congratulations to the teams who have participated before us. You have miles to go, but it was a great experience, and we really felt good in the company of young people. Thank you.
Thank you, ma'am. Now I would like to request Honorable Mr. Justice Sanjeev Banerjee, former Chief Justice of Meghalaya High Court and also a former Chancellor, to address the audience. Sir, please.
Namaskar and good afternoon, Sister Shampa Sarkar, for whom I have a lot of regard, because she's had her own battles as a woman, but does not wear being a woman on her sleeve. She goes about doing what she has to do on a matter-of-fact basis. Brother Solanki, who gave us a perspective of what it is to come from a rural background, get into a comfort zone, and give it up in the quest of knowledge. Kudos. Professor Dubey, for so well looking after my child. Professor Shukla, one of the first to extend a helping hand with, of course, Professor Goyal. When this was only being conceptualized, I invited them at the Chief Justice's residence, and on the gazebo we had this discussion, and they were all willing to help, and they did. Mr. Deburindo, part of my weekend family. Every weekend we would be out in the districts. I've shouted a lot of them. I've had a lot of meals with them. I hope I inculcated some knowledge and education into them, and I got a wealth of knowledge, affection and warmth in return. Madam Registrar of the Judicial Academy, her great contribution. She was the real first person of this NLU. She got the first notes. She made the first ideas. I'm sorry if I've, barked at you off and on. But most of us, except for carrying the bricks, we've done everything that was possible to set this place up. And we've got the assistance from many good people, such that you have such a wonderful campus as Justice Sarkar was referring to. I wish I could come here and study. And in fact, that was one of the things I told Professor Dubey, will you have me as a student?
I told him that yesterday.
But to today's moot court, my first confession. Each one of you speakers would have licked me when I was at your stage. All of you were very good. We grill you a bit. We try to, throw you off track just to test you. The problem was difficult. It was difficult to defend this. But you were all, you displayed the kind of knowledge that I did not acquire till probably I had finished 2 years in the profession. And you have years to go before you graduate, which shows us how legal education has improved and how our bright minds are being properly channeled. I salute all of you, and I wish I could have been as smart as you at your level. This is not a day for sermonizing, but the young students who joined, I must let you in on a little secret. Professor Dubey and I, we were sitting and talking about it. The CLAT was over. Admissions to most, desired institutions, law colleges had been completed. And then we were entering the fray. And I was afraid that we would get the dregs and not quality students. I came here for the first lecture. I don't remember whether it was on ethics or whatever. Then I came a couple of more times, including on the basic features, to celebrate the 50 years of the Kesavananda Bharati judgment last year. And some of the questions that I had to field made me absolutely jubilant as to the standard of students we had been able to get. And all of you should be proud when you leave these portals that it's really you who would have established the brick and mortar over here and the brick and mortar that is about to come up at the new campus into an institution. I've always emphasized there's a huge journey between a brick and mortar construction and that construction transforming into an institution. And I have hope in you and the wonderful faculty that we have, young faculty that we have, that, one day, if it's possible, if I'm grayer and probably fatter and less mobile, I'll come to see your campus and then think of the hard days that we had, fighting with the government, grabbing money out of them, coaxing, cajoling, threatening. But it was wonderful. And the cooperation that we got from the state government was exemplary in many ways. My wife Rani and I, we remember with gratitude our days in Meghalaya, the warmth that we got. Yesterday, as I was taking that trip for probably the 60th or 70th time from Guwahati to Shillong, all the memories, recent memories, kept rushing. There's some improvements that I saw on the way. Some constructions that had started have now been completed. I noticed outside the Raj Bhavan, there are 3 stones which have come up, which was not there when I left. And I found this campus to be more spick and span than I had ever imagined it could be. In fact, some of you may remember I would have come on several Sundays in my shorts to, surprise you with my visits, and quite involuntarily, quite without planning, got into conversations with you and tried to answer the questions, the many questions that you had, some of them being very searching, very appropriate, and very erudite questions. As Mr. Solanki said, and the good Vice Chancellor from NEHU, that it's always a continuous process of learning. The moment you think, I know enough, that's when you're doomed. There's only more to learn, more to know, and more to do. Please also be aware that you and I belong to that privileged class which can afford this education, this lifestyle, and our endeavor should be to ensure that our brothers and sisters, the rest of the citizens, can aspire to be in the same places, get the same education, so that democracy can be more meaningful. I wish you all the best. God bless you all. Mithila Shagun Kublai.
Thank you, sir. And now it's about time for which all of you have been waiting for with bated breath. I invite Jyotishikha Raj Kashyap, student convener of Moot Court, to give an event overview and declare the results.
Thank you so much, ma'am. Before we begin, I kindly request the technical team to present a brief video showcasing an overview of our inaugural National Moot Court competition in collaboration with the National Human Rights Commission.
How are you feeling being at Nlu Meg-Nhrc?
I'm feeling great. The atmosphere is just
Thank you so much. Now I would like to present a brief overview of
the first national moot court competition in collaboration with the National Human Rights Commission. I am thrilled to share that when registrations opened, the response was truly overwhelming. Close to 50 teams from various regions of the country eagerly signed up to embark on this journey with us. Many teams were unable to join us due to the limited registrations, which stands as a testament to the immense success of our inaugural National Moot Court competition. I am thrilled to see such a diverse array of participants from the northern reaches to the eastern shores and from the western plains to the southern hills. Our event has brought together teams from every corner of the vast and beautiful country. We started with 2 preliminary rounds and the researcher test on March 15th. Every team gave their best, and from there, 8 teams advanced to the quarterfinals for the next day. Then the best 4 teams from the quarterfinals moved on to the semifinals, also held on the 16th of March. By the day's end, we had the finalists who performed exceptionally well this morning in the final round. It is worth noting that the feedback from our esteemed judges has been overwhelmingly positive, with many acknowledging the performance of the teams. I'm filled with gratitude for each and every one of you who joined us for the event. We eagerly anticipate your participation in future events. Thank you so much. Now I would like to call upon Utkarsh Chaudhary to begin with the valedictory ceremony.
So we would like to begin with the prize distribution ceremony. So the best memorial for petitioner goes to TC 104, which is Damodaram Sanjeevaya National Law University. Please. So I would like to invite Mr. Sanjeev Banerjee to please give the awards. Honorable Justice Sanjeev Banerjee.
Distributed, everyone should be able to do it.
Yes, sir. Now, for the best memorial respondent, TC 117, Maharashtra National Law University, Nagpur. For the award ceremony, I would like to invite Mr. Jagdish Solanki, sir, to award and greet them with the prizes. Now, moving further, I would like other student co-convener Aparajita Prasad to carry on.
So, for the prize of the best orator male goes to Atharva Arnav from Damodaram Sanjeevan National Law University. I would like to call upon our VC sir to award them. Now, for the best orator female, the prize goes to Ananya Singh, National University of Study and Research in Law, Ranchi. I would like to call upon Professor Shukla to award them. Now, the prize for the best research goes to Ayush Dumka, National Forensic Sciences University, Gandhinagar, Gujarat. I would like to call upon Honorable Madam Justice Shampa Sarkar to felicitate. Now it's time for the runners-up team. Do we have any guesses? Can we hear it up for TC117 and TC105? Who is the winner? Can I get some cheers? So the runners-up team for the first National Moot Court competition by Nlu Meghalaya in collaboration with the National Human Rights Commission is TC117, Maharashtra National Law University, Nagpur. I would request Honorable Justice Madam Shampa Sarkar to give away the prizes. the winner for the first national moot court competition by Nlu Meghalaya and NHRC is TC 105, National Law School of India University, Bangalore. I would request Honorable Justice Sanjeev Banerjee sir to do the honors. As a token of appreciation for the hard work and innovative thinking of the participants, Takeoff has announced for the top 4 teams of the competition free access to any one of Takeoff camp, conference, or event, including accommodation of their choice. Now I would request Pranay Agarwal sir to come. Sir, please do the honors.
Good afternoon, everyone. As a token of appreciation for the hard work and the innovative thinking that has been reflected by the participants, the top 4 teams, the members of the top 4 teams will be having a free access to any one of the takeoff camps, conferences, or events that would be conducted over the next 2 years. Thank you.
Thank you so much, sir. Now we have a duet performance by 2 of our UG students.
শ্যামরাই কলিয়া ওহে বিনন্দিয়া ওহে বিনন্দিয়া বরং সরা কোন বনে সারিলা ধেনু হে হরি কদম তলে কানাই মুরুলি বজায় ওই রাম কদম তলে কানাই মুরুলি বজায় শ্যামরাই কলিয়া কৃষ্ণই বাহি বজায় ওহে বিনন্দিয়া যমুনার বালিতে শ্যামরাই কলিয়া কৃষ্ণই বাহি বজায় ওহে বিনন্দিয়া মাথারে মুকলি চুলি হে হৰি কদম তলে কানাই মুরুলি বজায় ওই রাম কদম তলে কানাই মুরুলি বজায় শ্যামকলিয়া গোতাজি পলাবি তয় শ্যামকলিয়া গোতাজি পলাবি তয় যমুনার বালিতে কদমৰ তলতে যমুনার বালিতে কদমৰ তলতে মেৰাই মেৰাই বান্ধিব তোকে শ্যামকলিয়া গোতাজি পলাবি তয় শ্যামকলিয়া গোতাজি পলাবি তয় বৃন্দাবনৰ মাজে কানো শ্যামকলিয়া গোধেনু চৰাই প্ৰভু শ্যামকলিয়া বৃন্দাবনৰ মাজে কানো শ্যামকলিয়া গোধেনু চৰাই প্ৰভু শ্যামকলিয়া ও বংশীৰামে গোপী মানক ভুলাই হে হে ও শ্যামকলিয়া গোতাজি পলাবি যমুনাৰ বালিতে কদমৰ তলতে মেৰাই মেৰাই বান্ধিব তোকে শ্যামকলিয়া গোতাজি পলাবি তই 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 Shamkolia kota jikola dito. Thank you.
UG students as well for another performance.
Kan ba soi hon udang mit dem Kan ba gading gadang hem Kan ba riti dang ban Jat ben riu kan dang inslem Asai hon udang mit dem Wat shaban lep non Tungin kedop riken dong Jingker men bakan long Kat bangi dang krela kaktin Jat ben riu kandang em Kasyong happy batna Bangin sumaryaka Tungin tinde akor burom Gaya yang keren kana Hasyong happy banyak Bangin sunda berserta Kan basai hon udang mitdem Kan ba gading kadang rehem Kan bari tidang ban Jat ben riu kandang inslem Wacha men bershiski Un wan tablo yapi We should restart it again. That's a mistake. Shall we start it again? Sorry. Shall we start it again? Okay. I apologize for the mistake because we actually got it. The lyrics are wrong. We got it wrong, so sorry. We're so sorry. So sorry.
Now I would request one of the members of, one of the participants of the winning team to come forward on the stage. 5 minutes. To share a few words about their experience with the competition. Good afternoon, everyone. First of all, I would like to thank Nlu Meghalaya and the organizing committee for organizing such a great competition. And for their first competition, I feel like this was really, really well organized. And as far as our experience goes, it was one hell of an experience just doing rounds during the day, then coming up with rebuttals throughout the night. So these past 3 days have been very hectic. And a big shout out to our team representative, Victor, for getting us printouts every morning of whatever we researched through the night. And yeah, I would also like to thank my co-participants without whom this would obviously not be possible. But yeah, thank you. Thank you so much. Now I would request Madam Badabhyang Takhar, Faculty Co-Convener of Moot Court Society, to deliver the vote of thanks.
It is truly a great honor to have a pan-Indian presence in this historic Mayurbhanj campus. First, I would like to thank all the participants who have come from far and wide to participate in this first ever NHRC in collaboration with Nlu Meghalaya. Thank you, participants. Give yourselves a big hand. We are truly grateful to have in our midst Honorable Mr. Justice Sanjeev Banerjee, former Chief Justice of High Court of Meghalaya. He's also the first Chancellor and the pillar of strength of Nlu Meghalaya. An institution is nothing without its foundation. We are grateful to you, Justice Banerjee. You are more than just a founder, you are family. I would also like to thank Honorable Madam Justice Shampa Sarkar, Justice Calcutta High Court, and Shri Jagdish Solanki, Advocate Supreme Court of India. I would also like to thank Honorable Vice Chancellor Nehu, Professor Prabha Shankar Shukla, as well as Professor D.P. Goyal, Director, IIM Shillong. I would like to also thank our leadership, Honorable Vice Chancellor Professor Indrajit Dubey. Without his unwavering support, nothing would be possible without him. We are also grateful to the caring hands and leadership by our founding registrar, Madam Kirpa Nongbri. Thank you so much, Madam, for always supporting us. We also thank Sir Debu Lingdo, who is the Joint Secretary, Law Department, Government of Meghalaya, who is another pillar of strength of our university. Thank you so much, sir, for being here. I would also like to thank the judges who have made time despite their busy schedule, coming from all across India, leaving their court cases behind to come and judge all of you so that you may improve, as future lawyers of this nation. Thank you so much to all the judges who've come to volunteer and participate in our first Moot Court competition. And most of all, I would like to thank our partner, the National Human Rights Commission, for entrusting such a young university to conduct a national moot court competition in our temporary campus. And we are so grateful to them for giving us this opportunity. I would also like to thank our sponsors, EBC, Loctopus, Live Law, Agarwal Associates, Legal Bytes, SEC Online, Tech Council Foundation, and Law Seco for ensuring to cover this moot court competition. Thank you for your support. And finally, they say that teamwork makes the dream work. Under the able leadership of my colleague, Yogesh Mishra, I thank you. And most of all, I thank the most important people here, our students of Nlu Meghalaya. They are just first-year students, and they themselves have never ever seen a national moot court competition. And yet here they are organizing a very grand function like this one. So I thank you, students. You have shown so much grace and leadership in organizing a big competition like this. And at such a young age, most of them being teenagers. So another thing, I would like to say that the dream team does not include just the faculty, but the dream team also includes the staff of the High Court of Meghalaya, the Judicial Academy,
and our dearest administrative team of Nlu Meghalaya, from the assistant registrars to the junior administrative assistants, who have been our biggest caretakers throughout this journey. Thank you for your support, and my fellow and dearest faculty. Thank you for carrying this through, from the hospitality to administration to whatever little it may be, from big or small. You never ever made an issue out of it, but you supported us nonetheless. Thank you for carrying this through. Nothing is possible with I, but you all have embodied we, us, and ours. So thank you, everybody, for being a part of this. I would also finally like to thank our tech support, Hubert and team, the catering team, and the cleaning staff for ensuring that this campus looks absolutely meticulous. Thank you so much for all your help. So with this, we've come to the end. Thank you, Khubleishi Hajarngo. I now call upon Jyoti Shikha, who is the student convener, Moot Court Society, to address us with the closing.
I, Jyoti Shikha Raj Kashyap, student convener, Moot Court Society, hereby announce that the first national Moot Court competition by National Law University Meghalaya, in collaboration with the National Human Rights Commission, is formally declared closed. I would kindly request the winners of Best Orators, male and female, and the Best Memorials petitioner and respondent to collect their checks from the reception. Oh, to collect their checks right now. And all other participants to collect their certificates and medals at the registration desk. I would also request all faculties and members of the committee to stay back for a group photo.